My lord, unlike extreme urgency, my lord, these two matters, my lord, your lordship has passed the order. These are, my lord, they lost their job in 2016, but they are also impaneled in upper primary. My lord, in counseling, they are impaneled. Your lordship passed an order that they should be called for counseling. My lord, Friday notice was served that from 21st, counseling is going to. I filed this matter long ago, but since counseling was not, my lord, conducted, your lordship's previous determination was the view that let there be an affidavit, or if the notice is served, then mention, my lord.
Has affidavits been filed?
No, my lord. But your lordship has decided the issue. After that, your lordship has decided the issue, my lord. 21st.
Case. Friday, let it appear.
My lord, I will serve notice to the commission. And my lord, another matter, my lord, item 46.
Urgent motion.
Item 46, my lord, today's list. I have filed this matter, my lord. I am a private school up to classes 1 to 8. My lord, the DM has put a padlock on my school without assigning any reason, and my lord are asking to shift the students. My lord, I am running this school for the last 15 years. This is, I have filed it, my lord. Item
Friday,
46.
urgent motion 46 today's list.
Under
Friday.
under extreme urgency, I'm mentioning item number 356 of the monthly list, but the petitioner is a cancer patient, stage 3, and she's not getting pension, Before, Honorable Justice Rito Kumar Mitra has heard this matter. Honorable Justice Rito Kumar Mitra has heard this matter, extensively, but due to change of determination, then, the matter could not be heard.
In that case, I release it. You can get the matter heard because his lordship has already heard it extensively. You say you can get it done because for this bench it has to be reheard, right? So it may take time. So do I release it? If you are agreeable, I can do that. Why no? You can get it done from there if the court has heard it to some extent at least, right? What is the item number? 356.
As your lordship may take it any day, but
See, going up to 356 will take some time. Try to understand. You have to understand. This is good for your client.
but assigning it will take more time, That's why, I'm
It may not take time. I will pass order today. I will.
Lordship may deem future proper. Any day.
But then this has to be hard all over again. Why don't you understand?
But it will, assigning it will take, whether they will assign or not, we cannot say, that is the whole problem, If your lordship kindly, petitioner is a cancer patient.
Item 300?
356, of
Is it in the motion stage?
it is in the motion.
356 টা শুক্রবার দিন দিয়ে দিন তো।
Extremely great.
Well,
My lord, honor.
I mentioned two matters, my lord. One is the regarding the pharmacy,
urgent motion নিয়ে আসবে।
well, regarding the affiliation of the pharmacy from the state of the vocational education regarding a pharmacy college, my lord. This ongoing process is going on for the finalization of the approval granted by the Pharmacy Council of India. Well, I did not get the clearance from the state. That is where the intervention of the court is required, my lord. Any day, item number 1717.
Some pharmacy matters have been fixed. I cannot recollect the date.
Even today, we have one matter, my lord.
Urgent motion?
We have urgent motion, item number 6.
In that case, Friday it will appear. Give and serve your other side.
I will
The
serve them.
respondent should be present.
My lord, under extreme urgency, one matter WPA 29899 of 2024 required to be mentioned. My lord, the petitioner Kwehli Mujumdar, who was to be recruited, and after a period after the interview, she suddenly was shocked to see that somebody else was being recruited there, who were not supposed to be. My lord, the petitioner is suffering from extreme economic stringency, and she is also suffering from physical ailments. Thus, the matter is required to be enlisted in the daily list from the monthly list. It's a humble prayer, my lord.
There is a date fixed in the list for upgradation. Please mention on that date. Check up the list prior to mentioning.
My lord.
May I have your lordship's gracious
Sure,
leave, my
please.
lord. I am praying for your lordship's leave, my lord, to move this matter on an urgent basis, my lord. The urgency is that, my lord, the petitioner before your lordship, my lord, is a physically disabled person, my lord, who is an assistant teacher, my lord, in a college. My lord, his salary, along with other 6 professors' salary, has been withheld, my lord, since the November 2023. We have made, my lord, persistent representations with the authorities concerned that, my lord, college follows the, my lord, rule book of the, my lord, AICT. We have made representation there too as well.
File it in the department,
My
sir.
only difficulty is that I am fully physically disabled. My lordship merely sees me my
No,
certificate.
no. So what is to be done?
What I am humbly beseeching before your lordship is that I want to move it on a short service, my lord. Because my lord, the only difficulty is that my
From 23, the cause of action arose.
my lord, that
In
point of time we have
26.
kept on discharging duties, my lord. The college authorities, my lord, on several occasions
Right.
assured us.
In 26, all on a sudden, the urgency crops
No,
up.
I tell
Please
you,
file it in the department.
I tell you,
I'm not
lordship,
going to accept it. Yes,
my lord,
madam.
in the
May I be permitted to mention a matter? Your lordship, in yesterday's list, your lordship, as item number 5, WPA 5009.
5 of today's list.
Yesterday's list, your lordship.
Yesterday's list 5.
Yes,
Why
yes.
are you mentioning?
Lordship, for inclusion of name, your lordship, for my senior's name, my junior, one of the junior had given the appearance slip, but it was not accepted in the court.
If it was not accepted in the court, you want the name to be inserted. And why was it not accepted?
Lordship, my senior was appearing online, but the appearance slip wasn't accepted by the.
Online.
Yes, your lordship.
If the person was not visible online, or at least nothing could be seen, then the appearance cannot be given.
Lordship,
Yes.
Lordship, it is very urgent matter. The writ petition has been filed by the petitioner against the college authority. The college authority is withholding transfer certificate and academic records of the petitioner.
Please use the microphone.
College authorities is withholding transfer certificate and academic records of the petitioner. He has already lost this one academic session and he is likely to lose this year also. So urgent, very urgent matter.
Is it
Kindly
there
the
in
matter.
the list?
No, it is not in the list.
There is a
It-
date fixed when matters will be accepted for inclusion. Mention on that date.
My lord, the petitioner before your lordship are the qualified teachers in
Why are you mentioning?
my lord.
Why are you what is the mentioning for?
My lord, may I be permitted to mention one matter?
For
My lord,
what?
my lord, the petitioner is a sin.
For what are you mentioning?
My lord, for inclusion.
There is a date mentioned in the list. Please follow.
Praying for inclusion, my lord.
No, don't mention.
My lord, may I just make one intelligence, my lord? On this January, my lord, they have issued me the salary statement. My lord, really sees it once.
File it in the department.
Then may I mention, my lord?
You file first. Yes.
Correction, my lord.
Why? What is the correction?
Item number order dated my lord 13 my lord writ petition number 27558 2025 order dated 2026.
There are 2 items, madam. This matter, madam, I appear as for the state, but the order is that none appear for the state, madam.
Lordship,
So 1 and 2 minutes, I am for the respondent.
All right.
Lordship, item 3, I'm appearing for the state. We do not have papers.
You do not have the papers.
Lordship, with the change, everything, Lordship, we've not been able to retrieve the papers from the erstwhile advocates because the AOR office does not. A copy of paper could be served on the AOR.
Doesn't have anything.
I'm so sorry.
Right. What is
I'm so
what is the prayer?
Dear my lord, the approval of his service, my lord, the as group D staff, DI by through email, my lord, online, there is no provision.
There is no provision.
Only online, just through email, my lord, the communication.
All right. Let him take instruction. Where is the order of the DM? DI or DI's order?
26.
26. Approval of service. Is it approval of service? There is no provision for approval of service.
Circular and also
Please come.
extremely scripty order.
The communication of the District Inspector of Schools, Secondary Education, Kolkata, dated 28th January 2026, is impugned in the instant writ petition. Stop. Learned advocate representing the state respondents is directed to revert with written instruction from the aforesaid respondent. Release the matter on 29th of July, fortnight's time.
Lordship,
A
in the
copy.
meanwhile, a copy with you. Grateful. 7204. Item 11, I appear for the petition.
Lordship, item 11, I appear for the state. I am also in the same
Appearing for the
state. I
Alright,
am
no
under the
papers.
same predicament as my learned friend earlier. So if I may seek a copy, and I suppose, Lordship, on last occasion, there was a direction for filing of the opposition from by the school. If I may seek copy of that as well.
What about the opposition of the state? Has that been filed?
Well, it is
Lordship.
the. Bolo fellow.
No.
No, copy didn't. Well, it is the decision of the school which is under challenge before your lordship. Well, the charge sheet which has been filed by the school is under challenge. So, well, at present, the state has nothing to do with the.
But let a
Lordship, but
copy be
maintain-
given
yes,
to him
Lordship,
so that
maintainability
he
is
gets
still
to
under
know
challenge,
what
Lordship.
is there.
We took point of maintainability. And on that score, we filed we filed affidavit in opposition. That is the affirm.
I see January 27, January, there is a direction for preparation and circulation of affidavit within 4 weeks. The time it has not been filed.
Reply.
We don't need
You
to
do
file.
not
No.
wish
It's
to.
the absolute point of law.
All right.
May I pray before your lordship one thing?
Yes.
If your lordship kindly place this matter after 2nd of August, 3rd of August.
Why? What is so special on 3rd of August?
Mr. Bari is leading me.
Yes.
Some difficulty if your lordship kindly requested me to pray before you.
All right. To allow learned advocate representing all the parties to come prepared, list the matter for hearing on 4th of August.
4th.
And Lordship, with regard to re-service upon the state, if
Yes, let a copy of the writ
I
petition
will do it.
Yes.
and the affidavit in opposition by the school be served upon the learned advocate representing the state respondents.
Great.
Thank you.
May it please your lordship.
So there was direction to file affidavits, my lord. I'm ready with the
Affidavits
affidavit.
are ready.
Well, kindly fix a date for the hearing of the matter.
Lordship, affidavits are ready. This matter, your lordship.
Reply is also ready.
Lordship, this matter, lordship, since November. Lordship, the petitioner before your lordship was she's an ex-vice chancellor of Calcutta University. She was appointed as an adjunct professor. And your lordship, this
Do we
appointment is.
proceed with the hearing today or you want some other date?
And led by Mr. Mojumdar or Pratosh Mojumdar, my lord, can kindly fix a date, my lord.
When?
My lord,
Lordship, fix it on Friday. Lordship, the students are suffering very badly, your lordship. Also, on the last occasion, lordship,
Friday.
time was taken.
Friday.
My lord, next Friday we maybe
Lordship,
come back.
next Friday would be difficult for lordship.
One week time, my lord, I'm paying.
Lordship, next Friday, it would be very.
Next Wednesday, 1 week you say, then next Wednesday?
Lordship, Wednesday, it will be, Lordship, from the 21st till the 31st, I would not be available, your Lordship. So, Lordship, will kindly keep it on Monday.
20th in that case.
The 20th.
20.
My
20th.
lord,
Well,
come back in case of difficulty, my lord, will kindly accommodate. We'll try to, my lord,
Lordship,
assist the
this
court,
matter, Lordship, since November.
affidavit in opposition on
we have
behalf
never
of the
paid for
respondent
time,
is
my lord.
1 to 3 and the reply thereto by the petitioner filed in court today be written with the records. List the matter on 20th.
20th, your
We are
Lordship.
grateful, my lord.
I'm grateful.
the matter any further, kindly dismiss this, and your lordship kindly take this as a part of the recording. It has to lordship.
My lord, on behalf of WBCDCL from Mr. Konakuran Bandapathy. He's engaged in
WB?
WBCSSC.
Central School Service Commission. Who is appearing? Are you appearing?
No, Mr. Konakuran Bandapathy.
Who is Konokiran? Where is he?
He's engaged in another court.
Then he should be here. Otherwise, how can names be recorded? Where is he? Tell him to come. All right. Let him come. Dismissed as not pressed.
Oblige the lordship. Sir, number 2 is yours.
Madam, for the petition. This time for the school session, my lord, come at my instance. My lord, after mentioning, my lord, I subbed upon the my lord, school service commission as well as on the board yesterday. So, my lord, here, my lord, what happens before your lordship, the petitioner, my lord, initially prayed for transfer on the ground, medical ground. So, my lord, this matter was taken up by this honorable court. This honorable court directed, since that was a zero enrollment school, so, my lord, that the case of the petitioner could be let it be considered by the district inspector of the concerned district. Thereafter, my lord, what happens? And this honorable court was also pleased to direct on me to make a fresh application for transfer. So immediately after I received this lordship's order, my lord, I made an application for transfer. So, my lord, while that particular application for transfer on my medical ground was pending before the district inspector, my lord, the district inspector, thereafter, my lord, the school service commission issued, my lord, an recommendation for transfer on administrative ground to a school which is, my lord, far away from the school in which right now I am also, my lord, working. So, in
the respondent number 5, who is the respondent?
My lord, is the Commissioner of School Education.
He was directed to file a report.
My lord,
the basis.
I subbed upon the Commissioner of the School, Commissioner of, my lord, on, I tell your lordship, they received it,
Who's
9th of April 2020.
Who's appearing for the state? Nobody?
I subbed on 9th of April.
No, did you serve the GP's office?
GP, they did not, my lord, receive at that particular time.
Right, it was in April.
Yes,
but
and then I served on by speed post. So which was.
But then somebody should be there for the state.
Yes, madam.
Will you appear? Because there is a direction upon the Commissioner of School Education to submit a report.
Administrative transfer, the direction comes from the Education Department, from the Commissioner. We only carry it out.
Now, my lord,
state law
problem today I am facing. My lord, the problem, my lord, today I am facing.
Not engaged.
My lord, is the my lord, issuance of the order of transfer in spite of the last order of this honorable court.
Where is? Oh, 1 minute. In which school are you rightly serving? Where are you serving now?
My lord, in that particular school where I was working, there was no student there.
So you are still there doing no work. Which school is it? Where is it?
My initial, my lord, Shoyadigi Junior High School.
All right, Purva Mendipur.
There.
Tomluk. And you have been recommended to.
My lord, that number I told you, lordship.
Shalika Godchok, somewhere, page 41.
Yes.
Right, it was in February 2026.
It is more away than the school in which I am right now working. Even in spite of the order of this honorable court.
And why do you want transfer?
On my medical ground. My lord, if I could take your lordship once, my lord, page number 31, 30.
Yes.
Well, this is this honorable court's order.
Petitioner single submit that the school is zero teaching school. Petitioner consider yes. All right.
So I was directed, my lord, to make a new application.
Right.
Which I did on the next page.
All right.
So, my lord, that is forwarded to the district inspector, page number 32. Page number 32, my lord. So now this application on at my own behest, my lord, was pending before the school, the district inspector at page number 32. In this meantime, yes.
All these things happen.
In this meantime, my lord, in spite of this honorable court's order, this transfer application being pending, they issued this administrative transfer order, which they
Page
can.
41.
Yes.
This is not the administrative transfer.
My lord, page
In-
41 is, my lord, the administrative transfer order. 10C. Lordship,
Ten-
please at the top.
Oh, 10C is
Yes.
mentioned. And your application for transfer is pending consideration before the DI. That is also there. Right. And now, what is the scope of the Commissioner of School Education to come in?
Now, my lord, on the earlier occasion, this matter was taken up. My learned senior, my lord, submitted before your lordship that the School Service Commission only carries out the order which is given by the Commissioner of the School Education for in the case of the administrative transfer. So this honorable court was pleased, my lord, to direct the school Commissioner of the School Education. Why, in spite of this application pending before the DI, you issued this
Administrative.
instruction on the School Service Commission.
But then,
Both the transfer procedures are totally different.
Yes.
One is under 10B, where the candidate prays for a transfer, and 10C is administrative, where the authority takes the decision.
Absolutely. And
So
the
there is no
authority.
violation in that sense of
No,
court's
true,
order.
but then the authority which passed the order under 10C was possibly not aware that an application for transfer by the petitioner is pending disposal at the end of the DI.
Actually,
Because there
Yes,
is
but-
hardly any
But
communication
that would
between
not
the
have been
DI.
an embargo. That is what I'm trying to
Maybe.
say. But
Maybe.
the health issue is to
Yes.
is what is
Right.
required to be
What
considered.
is yes, true.
Now, my lord, in this meantime, I have filed this supplementary affidavit, which the copies I have already circulated. My lord, I got this, my lord, day before yesterday.
দেখি এটা কি দিচ্ছে?
My lord, where your lordship will see my name. My lord, my name, last but one.
Shritilekha Haldar,
Last but one.
Purbo Mendipur SSS.
I'm directed to collect the transfer order, which was issued, which is impugned before this honorable court. And this honorable court directed that I will not be compelled or no order will be issued in my against me. Lordship has seen last order of this honorable.
Non-photocopy last approval of appointment memo of retention of such and such man certificate. All right. So I would require the fate of the consideration of the petitioner's application, which was made pursuant to the court's order.
My lord.
That is important.
Grateful, ma'am.
And till such time, page 41 has to be kept in abeyance in
This is my
respect
prayer.
of the petitioner.
Page 41 stage is over. Now it is before the board, the annexure to the supplementary affidavit.
It is in
So that-
continuation.
Yes, so that is
It is in
to be-
continuation.
That is required to be stayed because this has been acted upon.
Because page 41 is already stayed. My lord,
And 41 has been acted upon.
yes, yes.
Is it?
The full court said kept hold. So we wrote a letter to our CSC, Service Commission, report for clarification regarding 10C. That is not received.
What is the clarification will you to be given?
My instruction, it's an old instruction. May I come back?
What clarification? There is 10C order, there is 10C order. What is the clarification to be given?
MCC is there because of the Commission of India Election India order. There is needed clarification from the CSC.
If the clarification is required, it will be required for all candidates, not the petitioner alone. Because 10C, page your communication, West Bengal Board of Secondary Education, 13th of July. This is in respect of 14 candidates.
Yes.
It's a new fact, it's a previous one.
It doesn't matter. Ajay, please come. The petitioner is suffering from health issues for which she applied for transfer to a school close to her residence. During the pendency of her application seeking transfer on medical ground, the West Bengal Central School Service Commission issued a recommendation for transfer under Section 10C of the West Bengal WBSSC within bracket Amendment Act 2017, transferring No, not transferring, recommending transfer of the petitioner to a school which is far off from the school where she is currently posted. Stop. Challenging the recommendation. The petitioner filed the instant writ petition. The court vide order dated 2nd April 2026 was pleased to direct the board not to issue the order of transfer on the basis of the recommendation made by the commission till the disposal of the instant writ petition. Paragraph. A supplementary affidavit has been filed by the petitioner in court today, annexing the communication of the West Bengal Board of Secondary Education dated 13th July 2026. Annexing the transfer order of the petitioner. Stop. The petitioner has been requested to collect the order of transfer on 24th July 2026 at 12 noon. Stop paragraph. Submission of the petitioner is that the order of transfer dated 13th July 2026 has been passed contrary to the direction passed by the court in this matter on 2nd April 2026. Stop. Prayer has been made to restrain the board from giving any effect and or further effect to the order of transfer for the time being. Stop paragraph. Copy of the supplementary affidavit has been served upon the learned advocate representing the parties in court today. Stop. Learned advocate representing the board intends to revert with positive instruction on the adjourned date. Stop. The state. Now, learned advocate representing the state is directed to obtain specific instruction with regard to the fate of the petitioner's application seeking transfer on medical ground, which is pending consideration at the end of the District Inspector of Schools within brackets secondary education, Tomluk, Purva Mendipur. Release the matter for further consideration on 29th July. 29. The and 29th now. Today is 15th, to make it 22nd of July. 22nd July, next Wednesday. The learned advocate representing the state as well as the board shall come ready with necessary instruction on the adjourned date. Stop. The communication of the Board of Secondary Education dated 13th July 2026, annexed at page 6 of the supplementary affidavit filed by the petitioner, shall be kept in abeyance until further order.
Only with respect to the petitioner.
Only with regard to the
Only in respect of the petitioner.
And my lord, may I just make one request? Instead of 26, could it be made on 27th? Because I have got my personal leave on 26th.
No, 22nd I have kept it.
Oh, very well, very well.
22nd.
Very well.
26th is a Sunday.
I'm so sorry, ma'am.
He is becoming workaholic nowadays. He wants to come to the court on Sunday.
Great.
I'm appearing for the PCI, my lord.
I'm for the petition.
My lord, in this matter,
My lordship.
this matter, and he is engaging in court number 1. That's why
Who is he appearing for?
Department.
counsel.
For the
He is the main respondent.
He is the main respondent.
Vocational Council. Will you be able to carry forward? Will you be able to carry forward in his absence? No. What do? Do I wait for him? Pass over for the time being?
Not the time being.
Because if he is the answering respondent and if he is not here, then it will be
It will be
difficult.
taken up at 12 p.m.
That way it will be difficult. He'll come just now.
Yes, yes, my lord. Actually, court number 1.
Tell him to come immediately. All right, I'm passing it over for the time being.
One of in my another court one matter. I have one matter. If I fail,
adjust. Please adjust.
If I fail, Lordship,
I'll pass over again. I'll pass over again. What can I do?
I will be here.
All right.
If I go.
My lord, kindly seize the orders passed by this court on earlier occasions. The state was supposed to take the instruction whether there are vacancies in other medical colleges.
Is the state represented?
State Senior Standing Council, Nilanjan was.
Nilanjan Bhattacharya's name and Ms. Joita Dhar Chakraborty. Two names I
They are
can see
not
from
there.
the order.
Really, I will be the answering respondent.
You are there for the state? All right. The petitioner has prayed for transfer from Jagannath Gupta to any other suitable medical college. The immediate is that she is not able to attend classes from the institution where she is presently studying and she has suffered and to be made appearing in another college. Why is she not able to attend classes? Any particular reason?
That's very tragic reason. She has been so traumatized because of the sexual assault and harassment. Therefore, that's why she made a prayer before the authority forwarded.
When is the examination due to be held?
That I am told today, tomorrow.
Last date of form fill-up.
Well, the last date of form fill-up is today.
Today?
Filling up the form.
Filling up the forms. So with the filling up of forms, she doesn't have a problem.
No, but that has to be done from the college where from she will be appearing.
From the college where from she will appear. And thereafter, the transfer may be difficult.
No, may not be difficult. If your lordship directs, that can be done. In terms of the order of the court, Lord, we may fill up the form without prejudice, subject to the availability of vacancy in other college, which can be done also. I believe the state will have some instruction about the vacancy.
What does the instruction say?
Oh, good.
Where are those colleges?
Calcutta National Medical College.
Please make a printout and give it to your learned senior. All right, so that he gets to know where there are vacancies and who will be the authority responsible for.
I have no choice of any college. Whether I want to continue wherever they put me, I will be willing to go.
You'll be all right. Then the first one, you said
yes,
National Medical College. 2 vacancies are there. Then let the petitioner.
Yes, join.
Will anybody who are you representing?
I am National Medical Commission.
Commission.
Lordship.
What would be your say in the matter?
Lordship, my policy has to be looked into, Lordship, because
Yes.
my policy does not permit a student to transfer from one college to another.
No, but then if there is an issue with
Lordship,
regard
the thing
to.
is, nothing is the entire curriculum is like this, like LLB. I am reading somewhere, some practical, some projects are there. If I shifted to some other college, then Lordship, probably the degree has to be looked into and to be affected.
Degree?
Lordship, whenever a degree has every college, no, sir, every college has a minimum criteria for the degree. For the degree.
Not degree for admission probably.
Admission for admission. Degree means?
Degree means the MBBS certificate.
Yes.
Now, Lordship, the circular says every college, suppose in one college, the clinical paper is in 1 year, first year. In some college, it is in 3rd year. Suppose a paper which is in.
Listen, this is a very, not a regular incident. This is something very extreme, and we all have to protect the candidate,
True, Lordship.
right? If you want, you can take the names of the colleges where there are vacancies, find out the corresponding college where the petitioner can be
Lordship, probably
adjusted.
kindly see, this exercise on the last day also, we all stood by the student. Me, Nilanjan, we all stood by the student. We tried to accommodate. Now, Lordship, the only problem is there is a circular, and the circular has been
Sir, the court would want a solution and do not want to go through what the problem is.
No,
The
but to
problem is
reach
there.
to a solution, we have to reach to a path of law, Lordship. I must
Certainly. And if some tweaking is required, the court will tweak
Right,
that.
that court did.
So you please see
High Court did.
where the candidate can be
No, that-
accommodated.
that is not the thing. What may I submit, and then Lordship can. There is a circular which clearly says that there cannot be a transfer. That circular, the similar situation arose before Delhi High Court. Then Delhi High Court categorically said this is cannot be done. If if such situation is there, we have to. Then the circular is struck down. Earlier circular had this transfer system or something. The court struck down that. Now, after that, my client has gone to the Supreme Court. Now, Supreme Court has stayed that order. Sir, transfer has not been stayed, but that order has been stayed. Now, that means the circular by strength of which my client is saying that it cannot be done, I of course has to say that cannot be done, then Lordship can pass matter. That order is now before Supreme Court, and Supreme Court with a prima facie look has taken a view that this circular stands, you cannot. Why? Previously it was there and today it is not there. Previously everything was a government college. Now Lordship, now there is a NEET, there is a ranking, and there is a fee structure, and there is a course structure. 4 things. NEET ranking, transfer, then Lordship course structure, and the fee structure. Since now the parity is no more there. Previously, when what is there in National Medical College, same is there in the Bakura Medical College. There is no difference between. We had only 4 colleges: National, Nilratan, and then Bakura and Botala. Now, Lordship, in this scenario, once there is a private colleges has come in, then this circular has to be there. We have kept this. So what I will do before your Lordship is, this circular I will keep. The order against me passed by the Delhi High Court, that also I will place before your Lordship, and the Supreme Court stay on that. And Lordship, the doctrine which says that if a circular is there, unless the circular is declared ultra vires, court should not go beyond this. These 3 things I will say. Beyond that, Lordship is always having equity. Now, Lordship will use Lordship's equity to address the problem. Lordship, this scenario I must say before your Lordship. Because
All right. And I would like to see
No, but there will be no difficulty. The problem which is not talking of, this is under the same medical university. Therefore, the curriculum syllabus under the university is equally applicable for all colleges. There is no question of difference of the curriculum and subject wise.
there may not be difference in curriculum, but the NEET ranking which he is saying
I have been
may
admitted.
be proper.
I have been admitted under state quota. Therefore, there will be no problem in NEET ranking. NEET ranking would come at the initial stage. When the admissions are over, after the admissions are over, there are vacancies. It's not a case that somebody having better NEET ranking is being deprived. Therefore, that problem is there.
Please pass on the vacancy statement of the colleges so that the petitioner can at least go through it and give it to the commission also. Give hard copies, not like this. It will not be possible because it is more for the client than for the councils to go through it. All right. So you please give it and let the candidate fill in the application form.
মেডিকেল কলেজ আর্জিকর আমি তো এখানেই পড়ছি
মহারাজা পড়ছেন
হ্যাঁ আমি তো
না না মহারাজা কোচবিহার
সব
গভর্নমেন্ট হসপিটাল
সবই দরকার
I can see the last day's order recorded
Yes, Mala.
that on 10th of June it was recorded that the semester examination is to commence from 15th of June. That is over.
That is over.
All right. So now it is some other examination.
Yes. For third professional examination, there are मतलब 5 vacancies मतलब in 5 government colleges.
No, one Coach Bihar is not a government college. But I
government college.
suggested you.
Which was the government college? Which was the government college?
Acha.
Whatever your lordship deems fit, I want to ensure the career of the young girl.
Yes, true.
So these are
Let a hard copy, no, don't give it to me. Let a hard copy be circulated so that the parties can go through it and they don't know where they stand. Right. And if tomorrow is the last date for filling up the application forms for which examination you said? What is
professional examination?
Third professional examination.
This is the final examination for third year.
Third year.
She has to continue for another 2 years.
All right. Please come. The petitioner is pursuing medical education. Stop. She seeks transfer. Stop. The circular of the National Medical Commission of India does not contain any provision for transfer. Stop. Whether under extraordinary circumstances,
You have done your job honestly.
the candidate can be transferred to any other college so that her
Give me that circular.
educational career does not suffer,
Give me that circular.
is to be adjudicated by the court.
You downloaded that circular. No?
Stop. Paragraph, it has been brought to the notice of the court that the last date for submitting applications for the third professional examination is tomorrow. That is 16th July 2026. Stop.
No, that is very
Learned advocate representing the state respondents has obtained instruction with regard to the vacancies
up to 50.
in the medical colleges. Stop. Let the details of the vacancies of the colleges be circulated to the learned advocates representing all the respective parties. Stop. Pending consideration of the writ petition, comma, the petitioner shall be directed to submit her application form for appearing in the ensuing examination. Stop. The release the matter for further consideration on 21st of July, Tuesday, I keep it.
No, Lordship.
All parties
20
shall...
and 20 and 21st, I'm not here.
All right, in that case, 22nd.
Can it be 23rd if you are subject to the because
23rd is a Thursday. I will not like to hold back on that day.
then Friday, Lordship.
24th.
Yes, Lordship.
Can it be this Friday?
Yes, Lordship.
17th?
No. Lordship, keep it on 22nd. I will.
22nd?
22nd. And
all right, 22nd.
If
All parties shall come ready for hearing.
But one correction, when the last date is 15th July, today, not
15th?
Yes.
Means today. Acha 16th hoega jeta 15th hobe. Today. So you fill up the form and we'll see what is to be done.
Yes. But one silver lining, the Honorable Supreme Court did not stay the transfer of that candidate.
That's what I said. That's what I said.
So he submitted.
I'm obliged.
Well, can't you see the list of dates first?
My lord, before starting, my lord, I'm sorry to say, my lord, yesterday I came to know about it. My lord, we need to take an instruction from the department, my lord. Because
which department?
I myself do not know, my lord. Nobody is there to update the law. My lord, the brief was given to me much earlier, but no one from the department has till now
The
contacted me.
Ministry of Health and Family Welfare.
My lord, in this matter, perhaps, my lord, I do not know from the face of the record, my lord, it says, my lord, kindly come to page. I was just going through the read yesterday only. আমাকে একটু বলে দিতে দেন. Kindly come to page 41, my lord. As far I am for the state respondent, my lord.
State?
Yes, I am for.
I was thinking you were for the union.
I'm also there for the union, but in this matter, I'm not for the Union of India. My
Oh.
lord. No, something has also.
So
changed.
dual role you are playing.
My lord.
Then you can appear for all the parties.
My lord.
If your lordship wishes to, my lord, I can.
That will be easy. You can obtain instruction from both sides.
Point number 3 and 4.
3 and 4. National Board of Examination.
You are the Union of India, na?
He is the main person.
National Board of Examination. আলাদা।
ওটা কি?
National Board of Examination.
আচ্ছা।
There is a separate board. So maybe I do not know how much is your role. 3 and 4 is the answering respondent. Let the petitioner start. Are you ready with instruction?
Lordship.
Yes, then it's better. Let us start and if required, I'll adjourn. Yes, please. What is the
I
matter?
have a list of dates.
List of dates.
Oh, look. Short list of your list of dates was next week. First, next week.
Yes.
My lord, 20th February 2026, provisional admission letter was issued to the petitioner on the postgraduate medical counseling 2025, my lord, MD for MD. 24 sec 2 provisional allotment letter was issued to the petitioner with permission to get admission in Nilotun Sarkar Medical College under your open seat quota. 26 February 2026, the petitioner got the admission in cardiovascular and thoracic surgery, direct 6 years and continue classes. On 13/3/2026, college authorities wrote a letter to the respondent 23 for regularization of the admission of the petitioner. 24th April 2020, respondent number 3 in reply.
Please show me this communication, 13th of March.
My lord. 7, 8. College authority wrote, my lord.
Show me the communication.
Lord, at page they are going page 42, my lord. Why they are not giving approval for regulation of the admission? Page 42, my lord.
Page 42 is 27th of April 26.
My lord, the answer of
just now you read out 13th of March 2026. Where is that communication?
My lord, 41. Page 41.
Yes.
Page 41, my lord.
হ্যাঁ এটাই আমি তো এটাই বলছিলাম না 13 মার্চ দেখ না 24-এ কত চলছে 10-এ 10
My lord, same letter was given.
Just wait. I was able to see the subject in the choice basket now as per the existence such she should not be offered to an open candidate. Admission which was done in phase C. History vacancy would lead to cancellation of rest of all the allotment. And so rather than cancelling the admission, your request to exception. Yes,
My
then
lord,
what
page 43, my lord, principal also gave letter. Page 43, my lord. Page 43. 43, 44, and 45. The college principal also gave letter to the effect that later admission be regularized.
One India quota and two under the state quota designated for insurance due to apparent technical discrepancy during the council and process. One of the same displays an open seat. West Bengal DNB cell will be DNB cell. What is this cell? What is the DNB cell?
Ask the Bhavan liaison officer, I think.
DNB? The state will know what is this DNB cell to NBEMS.
My lord, kindly come at page 46. One second, my lord.
Now, due to some technical glitch, this seat has been shown as open instead of an in-service seat. This is the problem. This
Problem
the
is, my
court
lord,
can understand.
Kindly come to page 7, my lord, para 7, my lord.
No, look to the papers. Do not go through the governments.
No.
Papers, the documents.
Page 46, my lord, kindly come at 1 second. Page 46. The representation, my lord. And the representation was forwarded by the principal as well as department head, my lord.
Yes, madam.
Lordship, this is a post-graduation course. Counseling for 50% PGCs, which is handled independently by the state authority. Lordship, this is the for which the petitioner has applied. That is an in-service course, Lordship. That is allotted for in-service candidate. Here, the state, it is the responsibility of the state to look after all the seats which are for the in-service candidate and which are for the fresh candidate. So suddenly, for some mistake, this seat has been allotted to the petitioner. But
by showing it as an open seat,
yes,
it is there that the petitioner put in her application and she got selected.
Yes.
Now, what is the way out?
Attending the operation
Lordship,
classes.
it is an in-service course, Lordship. It cannot be the petition and
4 months, my lord.
it must be cancelled, Lordship. My submission is that because this is reserved for the in-service
There is no other in-service candidate. It is only because of the vacancy that this seat has been shown as open.
As per the clause, Lordship, as per the clause 6.5 of the information bulletin of 2025, up to 50% NBEMS accredited DNB include direct 6 years course seats in the hospitals, medical institution under the state government, railway, ESI, PSU, municipal corporation, etc. can be reserved for regular in-service candidate. 2 is for the in-service candidate, 4 was allotted for the Nilrathan Chakra. 2 is for the in-service candidate and 2 is for the fresh candidate. But by mistake, this was allotted to the fresh candidate.
It is not that by mistake, the mistake did not happen that way. There was vacancy, and that is the reason had it been filled up, she would not have got a chance. It is only because the seat was vacant that this has happened. Now, the state, what are you submitting? Now, the state has already communicated.
My opposition, Lordship, then let me file my opposition.
What is going to happen to the candidate?
Lordship, let me file my.
What is going to happen to the candidate?
Lordship, there is lots of document need to bring into the record, Lordship. That's why I'm
State there is a request from you to the authority.
Yes, ma'am.
Right.
The author NBMS. I need to bring into the record, Lordship. Then opposition is required, Lordship.
Do not be mechanical. You are handling with persons, right? State can.
There must be a vacancy for the fresh candidate, Lordship, because it is.
There must be a vacancy, and there is a vacancy makes a hell lot of difference. It is only because there was vacancy in that open.
Details of the seats, Lordship.
Details of the seats.
Yes, Lordship. The vacancy.
All right. You also produce your vacancy list.
That's why the opposition is required. I will bring into the record, Lordship.
Please come.
Stay around.
The matter relates.
My lord, kindly have your my lord. Follow.
Sir, ma'am.
Seat is converted to
এই
general.
ইউটিউব কি চালু আছে
Um,
লাইভ স্ট্রিমিং হচ্ছে কি
the
My lord,
matter
kindly
relates
come at page
to
39, my lord, 39. 39. In case of vacant seat,
Admission.
there is option of seat conversion as stated below, my lord.
admission in the postgraduate medical course. Stop. The petitioner has already been selected for admission, but her candidature is required to be regularized as she got admission in the open category seat. Stop. Paragraph.
ওপেন সিট কোটা
Acha, open seat quota. Stop. A request by the principal of the Nilratan Sarkar Medical College and Hospital where the petitioner got admitted was forwarded to the additional director, Department of Accreditation, National Board of Examinations in Medical Sciences, with a request for consideration of caps D small r NB within bracket direct 6 years admission under state quota. Stop. The same is pending consideration till date. Stop. Paragraph. The as the now the petitioner is already attending classes, but as her seat now as her admission has not been regularized, she is apprehensive with regard to her admission in the said course.
correction my lord perhaps my lord the petitioner is not attending the colleges right now
Not attending? Because this is the submission.
Can I? Ma'am, I'm not.
You will communicate to your advocate, and the advocate is going to.
Oh, she is,
No,
she is not allowed to attend the
Oh,
she is not allowing,
allowed.
my lord.
Just now you mentioned that she is.
2 weeks, last 2 weeks. Last 2 weeks. my lord.
When did the course start?
কবে থেকে start হয়েছিল? 26 February.
26th of February.
Well,
she got admitted on 26th of February
No, that doesn't mean the class started on 26th of February. You are not properly instructed.
my lord, as she is not regularized, she is not getting any stipend or anything like that. Last 2 weeks, my lord, she is not
You
allowing.
do not know what the matter is about. You do not know what the problem the petitioner is facing. You are thinking about the stipend. She has got a 6 years career.
yes
When did the course start? When did the classes start?
Start কবে থেকে start হয়েছে? 26 February starts.
On the day the admission was taken, from that day the
Join-
classes
from
started?
From the joining.
Acha. The petitioner. No, the petitioner attended classes on and from 26th of February 2026. But for the last 2 weeks, she has been restrained from attending her class, allegedly on the ground that her admission is yet to be regularized. Stop. According to the respondent numbers 3 and 4, the petitioner cannot be admitted in the said seat as the said seat is restricted for in-service candidates. Stop. As the petitioner is not an in-service candidate, that seat cannot be allotted to her. Stop. Learned advocate representing the state respondents is yet to receive instruction in the matter. Stop. Let the matter appear in the list next Wednesday. 22nd, staff learned advocate representing the state respondents shall obtain up-to-date instruction with regard to the request made by the principal of the medical college in April 2026 and the follow-up of the same. Stop. As the candidate has already, at a paragraph given, candidate has already submitted her admission fees and has attended classes in connection with a seat which remained vacant, comma, the proposal of the principal of the college to transfer the seat for a seat as opens under the open seat category shall also be addressed by the respondent numbers
My lord,
3 and 4.
my lord, that would be, my lord, transfer the in-service doctor's quota into non-in-service quota.
अच्छा, transfer the की बोलना मोटा, transfer the in-service quota,
Doctor quota to
in-service doctor quota to non-service doctor quota shall also be addressed by the respondent numbers 3 and 4. Instruction from the respondent numbers 3 and 4 shall also be placed before this court on the urgent date. Have you followed?
Oh.
Because there is already a request for transferring the seat from in-service to non-service only because there was vacancy. Had the seat been filled up, there would not have been this technical glitch and all these things. I'm keeping it next Wednesday. And please take proper, it will be there in the top of the list, do not worry. And please take proper instructions from your client. You are there acting on behalf of your client. If you are not properly informed, how will you place the matter?
Much obliged.
Yes, next.
But I am for the petitioner, my lord. The prayer of the petitioner is, my lord, the re-inspection. I am seeking the re-inspection.
Mr. Day is not yet.
Court number 1, there is a
Still
contempt
now
matter is going on.
continuing.
Yes, ma'am.
And here also the
I am seeking re-inspection, my lord.
by the which authority?
Re-inspection by the state authorities, my lord. The
Which respondent? Tell me.
my lord, re-inspection by the vocational training, my lord. It is
That
the
means Mr. Day's presence will be required. Please call him. Please call him. I'm passing it over. Just wait.
Yes, madam.
Yes.
Even my lord, I am the state.
My lord, I appear for the respondent university, Jadavpur University. Wortman University main.
I am the state.
Bardhaman Medical College.
Medical College. The answering respondent is the
Bardhaman Medical College.
Bardhaman Medical College is represented or not? Bardhaman Medical College is represented or not?
My lord, I appear for Jadavpur University, in which the petitioner is seeking admission.
Who represents Bardhaman?
Actually, my lord, dispute between the Bardhaman University and the petition.
Bardhaman University who represents?
Bardhaman Medical.
Bardhaman Medical College, the state will appear.
I am appearing.
Yes.
Then the state can appear and answer. Ready with instructions?
Actually,
No, actually, ready with instructions or not?
no, I did not get any specific instructions, but on the face of the record, I can.
All right, then the petitioner will place the
Very
case.
innocuous prayer that I want return of my credentials that is lying in the Bardhaman Medical College. I was got admitted to Bardhaman Medical College.
Show me. And why is it not being returned? No reason given.
No reason given.
Show that your documents are there. Where is your request for returning?
Request for returning is at page
28.
28.
Page 28.
Are the request for returning 28 kana bolche bache kotha
For returning. 37.
37 minute মাথায় যেটা ঢুকে থাকে সেটাই বলতে থাকে তো।
12th of June. I was admitted to the MBBS course at Burdwan during the accompanying session as deposited my original education class.
না তার উপরে কবে মেরিট লিস্ট পাবলিশড হবে? Today is the date for publication of merit list in Jadavpur University. That's the urgency. তার নোটিশ কোথায়? ও তো যশোকে ফোনটা তুলে দেবো?
You were facing some criminal charges or something you were mentioning?
Blood, that I did not disclose in the writ petition. I have said for my personal reason, could not continue. Personal and other reasons that I have mentioned in my letter. But that is what I have said before the court, that is the fact. I have enlarged on bail. All along, I was a brilliant
lodged the
student.
complaint? Who lodged the complaint? The college?
No. That has nothing to do with college.
Private party lodged a complaint?
Yes, madam.
All right. Yes.
Actually, I am inviting your lordship at page 39.
39?
Page 39.
Yes.
Here I find, my lord, one affidavit in the form of undertaking. My lord, lordship kindly see the
এই ইনফরমেশনটা লেখেন আমি কোর্টকে কি বলবো?
1 lakh rupees, 1 lakh had been
আমার
deposited
সামনে
at
কথা
the
হলো।
time of admission.
বোঝার কথা।
My lord, I am paying leave to read it out.
No, I have read it. The original documents which are in the custody of the institute will not be returned unless I pay a penalty of 1 lakh rupees. So 1 lakh rupees is to be paid. With 1 lakh rupees, the documents can be released.
Can be released according to this writ petition.
According to the writ petition. I have been declared as rupees 1 lakh if I resign or discontinue the course before completion of the tenure. Yes.
Kindly simulate.
Because one government seat will go vacant.
Similar circumstances, there was an order passed by the coordinated bench, relying on the circular of the UGC. I have the judgment and the UGC circular. Court has held that the UGC circular is binding and there is a strict prohibition on this penalty.
What does the circular say?
Second last clause.
Is this a circular?
Yes. And this is the order
Second
passed by the
last
court.
clause, verification and non-retention of personal certificates.
And this is the judgment passed by the coordinated bench in this year only.
Lord, this is not the part of the records.
In the month of June.
No. Second last, when taking the certificates into institutional custody under any circumstances or pretext is strictly prohibited.
And in these judgment also indicates that you cannot withhold them.
No, this is regarding validity and verification of the certificates. This is something different.
Return of documents as well as refund of money was the subject matter in this writ petition.
Let me see.
Appeal was preferred, ma'am. Appeal was preferred, but
Appeal has been preferred.
Yes.
And what is the order?
just a file.
Filed on Thursday. No stay as of now.
No, my lord. We have got
23rd of June, this order was passed.
the stay application. ওই এটা ফাইল কলেজ
There are other judgments of the Supreme Court also, I may come back with those judgments also, where the Supreme Court has held the UGC circulars are binding and having statutory force.
What is the interim relief that you are seeking now?
And only documents subject to final decision, outcome of this writ petition, whether I have to pay penalty or not, that can be decided by the court later on.
If the documents are returned, And if the court holds that you are required to pay penalty and you do not pay, then what is going to happen? How
But
can
there is certificate proceedings that state can always not try. Ultimately, when it's my career,
what is the position of your admission in Jadavpur
merit list will be
University?
published today.
Let the merit list be published. In the meantime, let the state council come. You see whether where you stand in the merit list, whether you get a chance or not. Everything will not be over by a day. In the meantime, let the state.
Let it be listened next week.
Yes.
এর মাঝখানে সমস্ত খোঁজ বার করুন, mark করে।
29th to stand to 1st August at any date.
No, next week is not 29th. Next week is prior. It is all right. We can keep it on 27th of July.
27th.
Acha. The petitioner took admission in the Burdwan Medical College. Stop. Took admission in the MBBS course during the academic session 2013 and 14.
Yes.
From 2013, we are in 26.
For a long period, I could not join that because of that criminal case.
2013, 14. 2013 and 14. ঠিক আছে?
দুটো প্রফেশনাল এক্সাম ক্লিয়ার করেছি, 3 নম্বরটা দিই।
Up to
Burdwan
second, I have
Medical
cleared.
College.
Yes.
He abandoned the course permanently.
He was not allowed to join in further.
Acha. The petitioner alleges that he was not allowed to join the course, not join, but to continue with the course on and from 2018 onwards. Stop. The paragraph the petitioner currently intends to continue with his studies in a different university. Stop. All his educational certificates are lying in the custody of the Burdwan Medical College, which the petitioner intends to take back. Stop. The Burdwan Medical College is not returning the documents to the petitioner. Stop. Paragraph. A request by the petitioner seeking return of his educational certificates is annexed at pages 37 and 38 of the writ petition. Stop. Learned advocate representing the state respondents is directed to revert with positive instruction with regard to the fate of the application made by the petitioner. Stop. The petitioner has already submitted his application form for admission in Jadavpur University, and he is expecting the results of the university to be declared shortly. Stop. Release the matter on 27th of July.
Every service.
Take back, yes, service. Take back all these documents, bring it on the next day.
No. Yeah. My lord, Mr. Shumande has come.
I'll just come back to you all. 8 and 9 are urgent matters and finish and come back to you.
Well, I appear for the petitioner in this matter. আমাদের তো নাকি?
Do you appear first?
Number 6 and 9.
First.
Mala, the improved order is, Mala, before your lordship, the Christian Service Society is now appearing.
Yes, 6 is there.
And this, they are the founder.
9 is there.
They are the founder of Bhimpur ABM Santal Girls High School, respect number 5. It is a founder body ballot for 3 institutions notified under the as a Christian minority institution. Malada petitioners, the society ballot had appointed respondent number 7 and 8 as teacher in charge and administrators. They have been served with the notice, madam. Notice has been sent, attempted to be served upon all the respondents. I understand they are appearing. Madam, the impugned notice before your lordship is at page 27.
Yes.
27 page. Madam, whereas Choitali Das, teacher in charge, so and so, high school has been found untraceable for a long time. DI writing. Along with the important official records and documents of the school as remained absent in school for more than 6 months. And whereas the teacher in charge of the school repeatedly failed to comply with the direction issued by the DI of schools. Whereas the Christian Service Society, being the founder body of Bhimpur, removed the previous administrator and appointed a new administrator. Whereas newly appointed administrator, being the appointing authority and disciplinary authority, relieved Choitali from the post of teacher in charge and entrusted Srimati Shobita Das to officiate as teacher in charge of Bhimpur Santal School. And whereas Shobita Das has assumed the charge with effect from 25/6/26, 9th of July when the order is issued, retrospectively from 25/6/26. Now, however, the circumstances after careful consideration of the facts and records available, this office in the interest of the ensuing smooth administration and academic functioning of the school, Shobita Das hereby accorded to continue to act as teacher in charge of the school with effect from 25/6 to 31st December 26 on stoppage arrangement or until further order. Mala, what is coming out from this particular letter, Mala? Firstly, that allegations of absence, let us forget for the time being. Authority is the Christian Service Society who has removed the administrator, and administrator in turn removed the teacher in charge. It is not the DI who is saying that I have removed it. What he is saying that founder body, Christian Service Society, has removed the administrator, and administrator in turn removed the teacher in charge. Now, I am the executive of secretary of the said Christian Service Society. I am saying before your lordship that there was no resolution by us, nor did we, my lord, give any notice to the DI of school saying that this administrator is removed. No date has been mentioned, no particulars have been given, and by this way, even 9th of July, Mala, he issued the order, and 8th of July, the requisition from the teachers have been received from the administrator and the teacher in charge, or existing administrator, teacher in charge, not the new. That is at page 28. School return has been received on 8th of July, and 9th of July, my lord, he's saying that founder body has given a notice that administrator is removed, and administrator has informed the DI that teacher in charge is removed. Malad, this has all happened, Malad. I should not speak much, Malad. I have very specifically paragraph 6, Malad, I have taken the point. The A, B, C, D, Malad, 4 points are there. The administrative order dated 9/7/26 has seen the light of the day only on 9/7/26 itself, and it has been given retrospective effect 25/6/20, which is wholly without jurisdiction. It is evident from the salary statement submitted by the administrator and the teacher in charge of so-and-so school, of the school submitted 8/7, that the said office bearer functioning as teacher in charge and administrator of the event on 8/7/26 and salary for June 26 is in the process of being disbursed on the basis of the online submission. And as such, the alleged notice 9/7 is bad in law, since the allegation of functioning of new teacher in charge from 25/6/26 of appointment of new administrator is suffering from perversity. Third, allegation made by Lord Choitali Sheet Hasda as to absence without intimation is bad in law on the face of it, as the same is a factual distortion of fact happened with regard to the absence of Choitali Das, has duly been taken leave on medical ground with the sanction of the administrator of the school, and the allegation as to the absence for long time without intimation has no roots. Allegation has been made against the teacher in charge being as to the flouting of the direction issued by the district inspector of schools Despite being called for several occasions, this allegation is manifestly bad and patently illegal, as not a single day or occasion TIC had disobeyed the direction of the DI of schools. There is nothing on record to establish that TIC did not respond to any notice calling upon her by the DI on any occasion against which TIC did not respond. The allegation is not only false, but the same is concocted, manufactured, and is a product of collusive act. This is very important, last but not the least. Further, the Christian Service Society had taken no resolution to remove the teacher in charge or administrator, being the respondent number 7 and 8, at any point of time, as is mentioned in the notice impugned dated 9/7/2026. Allegation made by the district inspector of schools regarding the decision to remove the TIC and administrator is bad in law. These are the grounds, my lord, has formulated before your lordship. We have specifically said, my lord, there is no such resolution. I am the society. I am the executive member of the Christian Society, under whom under whom these 3 schools are being run by this society and covered by Article 30 of the Constitution of India. And it is the power vested on the Christian Service Society, my lord, to appoint that administrator. And we have appointed administrator. Their appointment letters are part of the petition. Administrator was appointed. Kindly come to the approval of appointment of teacher in charge, page 26. First of all, the approval was granted in favor of the teacher in charge at page 26 on 18 July 2022. May I place it, ballot? In reference to the above mentioned subject, undersigned has to state that the appointment of Choitali of his school, now acting as teacher in charge, he is hereby approved with effect from 14 July 22 till the headmaster joins or the date of retirement, whatever is earlier. So Choitali Hasda will get the remuneration. This Choitali Hasda Mala is the existing teacher in charge.
But I am untraceable according to the order at page 27. Untraceable, the person is untraceable. I am the teacher in charge.
Yes.
Well, this book, lordship, will kindly satisfy your lordship about the status of the school as a Christian minority institution, my lord, and notified school. Right side page at the bottom. 3 schools are there, my lord, under the same society which I represent. So this removal order, my lord, that's an appointment of the administrator, my lord, is also, my lord, at page 25. That was pursuant to an order passed by the Honorable High Court, my lord, directing the DI to decide as to who will be the administrator. And this decision has been taken by the DI of school himself. Appointing, the petitioner has been acting as administrator. Kindly come to page 25, last but penultimate paragraph. Petitioner has been acting as administrator of Bhimpur Girls High School. Now there is no dispute between the petitioner and the teacher in charge. Petitioner is Proloy Kumar Shit, who is sought to be removed by the notice dated 9th July. No charge has been handed over. We have specifically pleaded here.
It amounts to interference in internal management of the minorities. I can't do this.
Yes.
So I am praying, before your lordship, the stay of operation of this order issued by the DI of schools, absolutely without jurisdiction.
Yes.
My lord, he is submitting.
My lord, we have received the instruction. My lord, DI is only the approving authority, my lord.
Approving
Yes,
authority.
my lord, because to approve the financial benefit, my lord.
Yes.
Because the TIC is a temporary.
If the DI is only the approving authority, then how is the DI passing order of removal, appointment,
No,
and
my lord.
everything?
My these are not these. If you will also kindly come to this memo, that is
Page 27 is impugned.
Yes.
my here is stated, whereas totally teacher in charge has been found untraceable for a long time along with all important.
Where from did the DI get
Because
to
my lord,
know?
has been communicated in the annexures, my lord. Page. My lord, it's the instruction received by the DI, where it stated that on 11/6/2026, Samshul Hansa, chairman, Christian Service Society, it has been communicated to his office that Shuklal Murmu assumed the charge of administrator of Mimbur ABM Shantal Girls High School, and in terms of letter dated 26/2026 of the administrator, Sri Choitali Sheet has been requested to hand over the charge of teacher in charge to Srimati Shobita Das,
newly appointed teacher in charge for fair and smooth functioning of the school. It is reiterated that post of teacher in charge in a school is temporary. The managing committee or the administrator appoint the teacher in charge. The district inspector school only approve financial benefit. As the administrator of the Bhimpur ABM Shantal Girls High School relieved
The instruction that has been forwarded to you and what is there in page 27 are contradictory to each other. Isn't it?
in the paragraph, last part, one paragraph, that as because it has been intimated that the erstwhile teacher in charge was
Where from the DI get to know that Choitali sheet, teacher in charge, has been found untraceable.
Because
Where from?
Yes, madam.
Is Choitali Das not attending school?
She was on leave, but now she's attending the school.
She is?
Yes. She's appearing.
And you are attending school? Then?
Preventing me now.
On 8 June 2026, this is to the district inspector of school.
Who has written?
Sub inspector of school. He made a visit and with due respect, that during my visit to Bhimpur ABM Shantal Girls High School on 4/6/2026 Thursday, accompanied by education supervisor Shiksha Bandhu and BLGE, I found from the attendance register that Srimati Choitali Sheet, TIC, of the said school had remained absent from the school since January 2026. Further, the attendance register for academic 2025 was not made available during the visit. It was not possible to ascertain the extent of her absence during.
How many students are there in the school? How many students do you have?
This is the.
But on 8th of July, Choitali has signed the return.
Do you have?
400 and some.
8th of July.
8th July he signed, Choitali.
Right, but for the last 6 months, the SI went there and found nobody was there.
She was on medical leave, or she
For
went
how
out
many
of.
days?
She was having from some vulnerable disease, that's why.
How many days? Has the leave been approved?
Leave have been approved. I have said it so. Leave was granted.
And leave for 6 months from
Leave
January.
was granted, my lord.
From January till July.
Exact date I cannot, my lord, vote to your lordship, my lord.
No, because you say 8th, she was there.
She was there in school.
Right.
And she was allowed to join. Had there been irregularity, she would not have been allowed.
Yes. You are the school and you are supporting
I am
Choitali.
not school. I am the founder body.
All right.
School is under me. Management is operating the school.
All right.
Administrator is operating the school.
Right.
And administrator also been served, what do you say, before your lordship?
Is Shobita a party over here?
Yes.
Yes, party. Who is appearing for Shobita? Respondent number 10, is anybody appearing?
Yes.
Who are you representing?
I am representing respondent number 6, the Christian Service Society, the founder body, and its chairman. Respondent number 9.
Respondent number 9.
Subhash Vyapari, Lordship, chairman of.
You are supporting the petitioner.
I am not. The question of supporting is, Lordship.
What is your stand?
Lordship, my stand is, Lordship, there were certain dispute between two
groups.
Two group of office bearers, I'd say like. Lordship, there was, Lordship, in a suit, title suit number 249 of 2024, the status quo was, order of status quo was passed, whereby this founder body, there are two sets of school, one is in West Midnapur district and another is in Bhimpur. So two fractions are, the administratorship is divided between those two varying groups. Now, Lordship, it is totally surprising that this office memo, DI is asking that DI is stating that some administrator has removed the TIs. Lordship, the fact remains that there are two groups of rival groups are two. One has filed this writ petition, and another is my client. None of them has done that.
None of them has done that means what?
None of them means neither the founder body nor any administrator has instructed DI to remove the present TIs. Now, for us, Lordship, it is.
What is the role of Shobita Das?
Lordship, Shobita Das.
He's an assistant teacher.
Assistant teacher in charge.
I understand it is she who has been directed to take over charge as the teacher in charge.
One thing is something is troubling me, Lordship. If my lord kindly comes to page 28, Lordship, Lordship, this document is the submission of salary submission form, it is said. Page 28.
Yes.
Now, Lordship, the number 1 candidate is the TIC. It is written there. Means in the government document also it is written TIC on 8/7/2026. Surprisingly, the TICA, the allowance, Lordship, in the small columns, Lordship, pay in PP, GP, AGP, BP, TICA. This has been removed, this has been made 0. So, Lordship, I believe there is some unauthorized tampering with this document, Lordship. Possibly, Lordship, DI has access to this also. He has also removed this, and to my instruction, Lordship, the founder body has not given any instruction through his administrators to change the TIs.
Teacher in charge
Of this particular school, Lordship. And surprisingly, Lordship, the day after, Lordship, we have received another notice that has not yet been added in this writ petition. Same thing, Lordship, regarding another school.
All right. Petitioner, tell me, page 27 is not standing in the way of the regular functioning of the school. Somebody is already officiating as the teacher in charge. Let the teacher in charge come.
The teacher in charge has not been functioning. We have not handed over the charge. That has been averred in the petition. Charge has not been handed over to the teacher in charge, no person. But I have come immediately on notice of Friday.
If the handover is not done, then there will be problem in disbursing the salaries and everything, day-to-day expenditure and everything.
That is exactly for which you have before your lordship.
Yes.
School should not suffer. Malak, in paragraph page 11 we have said.
No, but then why will you not hand it over? We will see what is
Because
going to happen.
9th of July, Malad, is a date, Malad, is a Friday, which was served in the school.
Yes.
And Monday, Malad, we move the matter before your lordship,
Yes.
Malad, immediately. That we have not handed over charge, kindly state. Lordship granted me leave to move it today and serve it.
Yes, that is all right. But then I do not find immediate reason to state. Let
Because it is
Shobita come.
without jurisdiction on the part of the DI of school, because the service society has not passed any order on
All
that.
right, please come.
Christian Service Society, Malad, is the source of their power. He has not issued any order.
Being memo number 952-S dated 9th July 2026, issued by the District Inspector of Schools within bracket Secondary Education, Paschim Mendipur, by permitting Shobita Das, the respondent number 10, to continue to function as the teacher in charge of Bhimpur ABM Shantal Girls High School with effect from 25th of June 2026 to 31st December 2026 on stopgap arrangement or until further order, whichever is earlier, is impugned in the instant writ petition. Stop. The petitioner is the Executive Secretary of the Christian Service Society of Bengal, which is the society that is running the subject school. Stop.
Is a founder body.
As a founder body, which is running the subject school. The society is the founder body which is running the subject school. Stop. It has been submitted that the DI acted without jurisdiction in interfering with the internal management of the Christian institution, which is governed by Article 30 of the Constitution of India. Stop. The impugned memorandum contains certain statements which, comma, according to the petitioner, comma, is absolutely incorrect. Stop. The prayer has been made to stay operation of the impugned memorandum, or else the functioning of the school and day-to-day management of the affairs of the school will suffer. Stop. The erstwhile teacher in charge is yet to hand over charge to the erstwhile teacher in charge, being the respondent number 7, is yet to hand over charge to the present teacher in charge, the respondent number 10. Stop paragraph. Learned senior counsel representing the respondent number 7, that is the teacher in charge who has been removed, submits upon instruction that his client is regularly attending this school.
So this will be evident from page 28 itself. My signature will be erstwhile administrator. That is updated 8 June 2026.
8 July.
8 July. Sorry.
Yes, stop. It has been submitted that there has not been any complaint against the erstwhile teacher in charge from any person whatsoever. Stop.
No, this is a salary list.
The district inspector of schools ought not to have interfered in the administration of the minority institution. Learned advocate representing the respondent numbers 6 and 9.
6 and
9. 6 and 9. Being the Christian Service Society and its chairman, comma, the founder body of the minority institution, also submits that no complaint was ever made against the erstwhile teacher in charge before any authority. Paragraph. The respondent number 10, comma, the present teacher in charge has not entered appearance. Stop. Who is this respondent number 11? What is the allegation?
He is one of the member, my lord, of the society. There is no allegation against him.
No allegation.
Advocates representing the state. I think, Lordship, he has been appointed as an
Yes,
admin.
my lord. He is assumed the charge of administrator. Recent administrator. This one number.
The
11.
learned advocate representing the state respondents has obtained instruction from the sub-inspector of schools, comma, Shodor South Circle, Paschim Mendipur, signed on 8th of June 2026, which mentions that the sub-inspector of schools visited the subject school on 4th of June 2026, accompanied by the education supervisor, comma, Shiksha Bondhu, and BLJE. And it was found from the attendance register that Choitali Sheet, comma, teacher in charge of the school, had remained absent from the school since January 2026. Stop. The attendance register for the academic year 2025 was not made available during the visit, and it was not possible to ascertain the extent of her absence during that year. Stop. It is under such circumstances that the district inspector of schools thought it fit to appoint a teacher in charge for smooth functioning of the school. Stop paragraph. Upon hearing the submissions made on behalf of both the parties and on perusal of the materials on record, it appears that the fact that the school is a minority institution has not been disputed by any of the parties. Stop. The extent of interference by the district inspector of schools in the administration of such a minority institution is to be adjudicated. Stop paragraph. As the district inspector of schools has forwarded the attendance register for the period January 26 till June 26, which clearly shows that the teacher in charge was absent and for which a decision has been taken for appointment of another teacher of the said school to act as teacher in charge as a stopgap arrangement, comma. Accordingly, the court is not inclined to interfere with the impugned office memorandum at this stage. Stop. The district inspector of schools is directed to file an affidavit disclosing what prompted him to enter into the administrative affairs of the minority institution. Stop.
The administrator has been changed. That is also without jurisdiction. He cannot do this.
My lord, this is the instruction.
We have
my lord,
not recommended for that.
My lord, this is on 11/6/2022. My lord, on 11/6/2026, my lord, it was communicated by the Reverend Samsul Hansa, chairman, Christian Service Society. It has been communicated to this office, the office of the DI, that Shuklal Murmu assumed the charge of administrator, or that is response number 11.
Shukla Murmu administrator?
No, yes, my lord. This is the instruction, my lord. If you will kindly. This is the instruction.
Yes.
Last line, my lord. He has been.
Who was the erstwhile administrator?
Proloy sheet will have shown your lordship the appointment letter. Approval of DI about Proloy sheet.
Proloy sheet 8. 8 is represented by anybody?
Yeah, myself, your lordship.
You are there. 8, you are 7 and 8 both. All right.
At that time,
Page
7 was
25, the approval of 8. DI approved him.
8 was the teacher administrator and 7 was teacher in charge at that time. After change administrator, that is the new respond number 11. As per the communication, he became the administrator, and accordingly,
how could you change?
Accepting that. This is internal management.
It has been communicated to my lord.
He will not verify.
কি বললাম ওটা রিপোর্ট দিতে বললাম
And he will act upon that.
Yes. The respondents are directed to file their respective stand by way of an affidavit. Stop. Such affidavit shall be prepared and circulated within a fortnight from date. Stop. Exception, if any, may be filed by the petitioner within a week thereafter. Stop. List the matter immediately after completion of the aforesaid time period. Stop. The arrangement made by the district inspector of schools. Now, the arrangement reflected in the impugned office memorandum shall be taken as a temporary measure, and the same will be subject to the result of the writ petition. Stop.
And the salary requisition should be acted upon so that the salary may be disbursed. at page
That should
28.
be done by the current
No,
administrator.
it has been accepted by them, my lord. That was written, that communication was made thereafter. 9th July it has been sent. 8th of July it was sent. 8th of July there
understand.
was no order of the DI.
Understand.
8th
Yes.
of July, no order of the DI. You
Achha.
should act upon this.
The salary requisition of the school, which was submitted before
month
the
of June.
authority for the month of June 2026, prior to the issuance of the impugned memorandum on 9th July 2026. Shall be acted accordingly.
Yes.
The instruction by the District Inspector of Schools, Secondary Education, Paschim Mendipur. Filed in court today, be written with the records. Undated instruction.
Matter on a particular day.
Immediately, 2 weeks and 1 week.
Kindly give a date, my lord. We shall communicate to all parties, my lord.
Please communicate immediately.
This appointment of this new so-called new TIC and administrator, Lordship, may it be recorded, Lordship, on there will no equity created on that basis.
It is recorded that it is absolutely temporary. It
Right.
is abide by the result of the writ petition.
Lordship,
So,
what happens, Lordship, Lordship, in these matters, Lordship, in this school, Lordship, in this matter, Lordship, the person, Lordship, who has represented himself as the chairman or of the founder body, Lordship, he will be starting to create in other legal areas. He will be now using this order as a stamp on his authority. He might use, Lordship. So, Lordship,
if somebody may think that he is the king, then let him think. Why will no?
He has accepted the administrator.
Temporary. He has mentioned it is temporary.
Temporary stopgap measures, my lord.
अच्छा एक line लिखे नहीं तो no right or equity will be created in favor of either of the parties in acting as the teacher in charge or the administrator of the school in terms of the impugned memorandum. Because I see that Proloy sheet appeared before the court in earlier writ petitions of 2017 or something. So there are issues with the institution.
Sort of societies, your losses will rivalry.
Rivalry.
That doesn't give right to the DI to accept someone. It has to be through proper resolution of the society of the parent body.
Yes, 9.
My lord, instruction will be kept on record, my lord. Instruction will be kept on record.
Yeah, sure, good. করে দাও এটা এ নিয়ে মারামারি করে কি আছে?
Lord, I appear on behalf of Central Board of Second Case.
My lord will kindly turn to page 95 just to show, my lord, that the petitioners future prospect is so bright.
95, yes.
That the petitioner got an offer, my lord, from Oriel College, Oxford University for admission.
To read mathematics and philosophy
Yes.
for admission in October 26 on condition that you obtain the following grades in your
Forthcoming examination in the current academic year. Year 12 qualification studied CBSE board with grades A11, A11, A2. Now the petitioner obtained, my lord, all these, but in one particular English, he was given A2. My lord, I immediately applied for review. Kindly come to, my lord, my page 98. My lord,
request for re-evaluation.
yes.
Yes.
Kindly note the date and time. This is
Yes.
very interesting.
6th of July.
No review was made. People have undertaken AI. AI cannot go above the human intelligence. Kindly see the 5th of July 2026 at 8:59 p.m.
Is it 5th or 6th?
5th.
All right, 5th July.
Then kindly come to, my lord, the next page 100.
Yes.
Your lordship will notice 5th July 2026 at 9:17 p.m.
Mm-hmm.
Therefore, my lord, within few minutes, they, my lord, reject the review. On what ground? Each answer book understanding evaluation was checked by two evaluators in accordance with the prescribed procedure to ensure a fair, transparent, and objective assessment. The marks awarded after re-evaluation are based only on actual merit of the response. My lord, this is the AI response. This is not, my lord, the evaluation by any experienced teacher. And not this evaluation, my lord, by AI
And
cannot
what is the difference between A1 and A2 marks?
different grade, my lord.
Yes, how
Marks,
much is
I don't know what marks they give everyone. 4 marks, I'm told. 4
4
marks.
marks?
Now, my lord, kindly come to, my lord, the norm of, my lord, the awarding marks. Since they have handed over, my lord, to the model answer key at page 123, on the basis of which, my lord, the 125 is the method of assessing the skills. But this cannot be done by AI. Kindly turn to, my lord, page 125.
Yes.
Well, this is the way, my lord, they have to assess. And kindly turn to, my lord, page 128. They have given them, my lord, a model. Kindly come to question number 3. Attempt any one of the two. How the marks will be received? The format 1, content 2, expression 1. This is the way marks will be given. Now, my paper, my lord, on the basis of the model answer was answered, my lord, was checked by two experienced teachers. They have given a certificate saying that the assessment was completely wrong. I want, my lord, a review by a third expert. My lord, that will, my lord, really open the door for my, my lord, future prospect in the academic field. Not by AI.
All right, let me understand whether it is by AI or whether it is by somebody else.
Therefore, otherwise, in 10 minutes, it cannot be done. Tarao, don't you?
98 and 100.
And my lord, we'll kindly see the expert's opinion at page 91, 93.
No use going into
Yes, yes.
private expert's opinion. Page 98, there is a request for evaluation, re-evaluation. Has that been responded?
Yes.
Yes.
My lord, there is a procedure. My lord, there was a notice issued by CBSE, my lord, in the month of May. Now, my lord, there is a procedure for obtaining, the revaluation task. The first procedure, they have to obtain the photocopy. Then they have to apply for verification. Now, verification is confined to calculation of marks, and transfer of marks from page to index. So, whether it is accurate or not. Thereafter, they can apply for evaluation. That was done. This was, my lord, reevaluated by two subject experts. Now, there is a procedure. All my lord, procedures have been, modalities have been, my lord, complied with, and that has been, my lord, completed. My lord, kindly see, only the petition was served upon me day for yesterday. Yesterday, I could not come, my lord, for some personal reason. My lord, however, I have obtained a written instruction.
Yes.
My lord, the procedure is that
the candidate wants re-evaluation.
Yes, that has been done.
That has been
That
done.
was done. Kindly see their letter, his letter, 98.
Page 98.
98.
Is it dated? It must be dated 5th of July 26. It's at 8:59 p.m. A request was made.
I am a former CBSE student who had appeared for CBSE class examination this year. My English exam had gone very well, but when I received my results on 13th May, I was shocked as my marks in English were far lower than what I expected. Hence, I applied for photocopies of my answer script and applied for evaluation marks in all these questions where I felt more marks were deserved. I applied for the photocopies on 20th May, received them on 25th May, and applied for evaluation on 2nd June. Kindly note the date. 2nd June.
But even after evaluation, no marks were increased in English. I had applied for 11 marks for evaluation after consulting several English teachers and head examiners from my school, as well as subject experts such as Ma'am Hilda Pincock, so and so, so and so. They have gone through my English script and have confirmed that my claims are valid and I deserve the marks I am asking for. I humbly request CBSE to reconsider and reevaluate my English paper with respect to the marking scheme. In January 26, I received an offer to study mathematics and philosophy at the University of Oxford from Oriel College, so and so, this. Then I am attaching my final CBSE result along with my English answer booklet, explicitly showing the discrepancies as well as my offer letter from Oriel College. Now, my lord, kindly, I'm sorry, I was not well.
Take your time. Huh?
My lord, revaluation, it was, kindly take the instruction, my lord. It was the revaluation was done by two subject experts, not to each other. And now, my lord, they have confirmed that there is no mistake, there is no thing. So on that basis, my lord, the response was given. Now your lordship knows that, my lord, the procedure, my lord, a learned friend is seeking my learned senior friend is seeking an order, my lord, from your lordship, for appointment of a
that the court is not
independent expert.
Certainly
So,
not.
my lord, that is not, my lord, my respectful submission. That will create lot of.
The court just wanted to know, because the submission of the petitioner was that the application was made on 5th of July at 8:59 p.m. and immediately on the same day, the reply came at 9 p.m.
Oh, my lord.
17 p.m. Right?
This kindly see the dates.
Yes, he made it.
Evaluation
He
was done
applied
in May, June.
Right, 2nd June he applied for re-evaluation.
Then it was found that there was no mistake.
Right.
Then, my lord,
this is the communication you only made.
Because I find that this communication was in response to his representation.
Earlier representation of 2nd of June.
2nd July. Prior to that, the revaluation was conducted because my lord, kindly see the notice, general notice. There are dates given.
Yes. The moment you say that the re-evaluation was done by two experts,
yes,
the court will not enter more in the matter. This is all. Yes, petitioner, what will be your submission? 2nd of June, you applied, and the communication that you are showing is a 5th of July. So your application was considered earlier. And where is the scope for getting an answer script re-evaluated by a third person?
Now, the question is, my lord, that the CBSE, if somebody raises an issue, says you have followed your procedure, and the expert, my lord, in the field, who is not related to me or, my lord, to the particular school, finds that the evaluation was not done properly. Why?
Third party evaluation. No,
My
sorry.
lord, they are not third party as such. They are all, my lord, renowned teachers.
Their letters.
What would be the CBSE's?
What will happen if one after another student comes for re-evaluation?
Lord,
You please do not make this type of submission. Sorry, sir.
one after other students have not come.
They will
Nobody.
Courts have shut doors from the word go.
No, I follow.
So then it cannot be done. Sorry, sir.
Let it be without
Let
that.
the candidate try out somewhere else. He may not get in this college. He'll get in some other college. Where is the difficulty?
The question of that is getting to other colleges is different than someone getting from Oxford. The quality of education.
Oxford means That level has to be
That
achieved.
he has achieved that level.
It is he
But
who, that is self-assessment. I have achieved.
No,
But the evaluators found.
now, Lord, the Oxford has been
Sorry, please come.
granted him sanction. Admission is allowed, subject to
That is always provisional. This admission is provisional. The petitioner appeared in the CBSE examination.
Kindly, before Lordship, sorry, kindly excuse my impertinence. Kindly turn to Lord page 108. How this is done this time, Lord, the CBSE.
108.
Yes. Why Rob asks of a marks CBSE class 12 students in blame digital evaluation for low scores. This is not, my Lord, only case where, my Lord, one individual is before Lordship. My Lord, this is the general grievance everywhere.
It
Therefore,
cannot
if
be
the
done.
CBSE will not really sees that an expert of their schedule.
Please take. If you do not have confidence in the board in which you are appearing for the examination, then you should have changed the board.
I would have been happier, my lord, if my lord he gets admission. But
So that is different.
yes, that's a
Everybody will be happy if somebody gets admission in a college like Oxford. Absolutely.
Then an exceptional case, my CBSE should agree, my Lord, to refer it to their own expert.
There may be so many other candidates with same grievances. Acha. The petitioner appeared in the CBSE examination 2026 and secured A2 grade in subject English. Stop. He applied for re-evaluation of his marks, and on re-evaluation of the same, the petitioner was intimated that there is no change in his marks. Stop. The petitioner is aggrieved by the same. Stop. Allegation is that the re-evaluation has not been done by the subject experts, but by artificial intelligence. Stop. Prayer has been made to direct the board to re-evaluate the answer script of the petitioner by independent subject experts. Stop. Learned advocate representing the Central Board of Secondary Education relies upon the instruction forwarded by the authority and submits that the re-evaluation of the petitioner's answer script was done by two separate subject experts and not by the help of artificial intelligence. Stop. It has been submitted that there were prescribed timelines and dates within which applications for re-evaluation could have been made by the candidate. Stop. The petitioner applied for re-evaluation of his answer script on 2nd June 2026. It is only after he communicated on 5th of July 2026 that immediate response was given on the same date, intimating that there was no change in his marks. Stop. Paragraph. It has been submitted that there is no provision for appointment of third-party experts for re-evaluating the answer scripts. Stop. Upon hearing the submissions made on behalf of both the parties and on perusal of the documents placed before this court, the submission of the petitioner that the re-evaluation of his answer script was made by artificial intelligence cannot be accepted by the court. Stop. The board has specifically mentioned that the re-evaluation was done by two separate subject experts. Stop. There is hardly any provision for, there is absolutely no provision for appointment of third-party examiners / experts to re-evaluate the answer scripts of the examinees. Stop. If such prayer is accepted, then there will be floodgate of matters where candidates may approach court seeking re-evaluation of their answer scripts by third-party experts. Stop. The such practice has not been accepted and on the contrary, highly deprecated by the Honorable Supreme Court. Step next. In view of the above, no relief can be granted to the petitioner in the instant case. Stop. The writ petition fails and is hereby dismissed.
May I make a very humble appeal? That will also not appeal to them. Not the third party, but let it be done with their own head examiner.
Second time.
Their own head examiner.
Second time.
Maybe.
No, sir.
As an exceptional case.
No, sir.
Yes.
Yes, call the Passover matters, please. Item number 3. Yes, please.
For the Pharmacy Council of India. Probably the matter has become infractious.
No, my lord.
No.
Academic year.
It was in March 26 that you filed the writ petition. And we are in the mid of July.
There is no scope for giving
Lordship,
affiliation.
So
The next year,
a few months ago, the
has
affiliation
been started. Next year's court has been
My
started.
lord, a few months ago also they have given affiliation. I will show you. Lord. But this is my report. On the previous day they have filed. Lordships. One institute come before your lordship.
What is the immediate relief that you are seeking?
Admission.
Admission. For which academic course and year?
26, 20, 25,
25, 26.
25, 26.
25-26 course is long over. Now it is 26 and 27 course. 25-26 course you want admission. Right? Right now the course is over.
No.
Second semester is going on.
Second semester is going on, but a few days ago also they have given application.
You are a college and you want affiliation. You are a college and you want affiliation.
PCI already given us affiliation long back, but the State Council has not given approval with some. Lordship can see on in the year 2022-23, they have given PCI given.
These are all sham colleges, isn't it?
No.
No students.
There are students. There are students.
Yes, in your register there are students. There is money coming in. But actually you will not find any students.
Lordship kindly say that is not correct, my lord.
Not correct?
Not correct. That is not correct. Lordship kindly see in 2022-2023, PCI given us affiliation as well as council given approval. We running the institute. 2024-2025 they have given. 2025-26, my lord, it has been said that we have some deficiency, so we will not get approval. But the PCI given affiliation after inquiry. After inquiry, it has been given. My lord, we prayed before your lordships for 25-26. My lord, on the previous occasion, my lord, lordships, previous coordinate bench directed to file a report. My lord, from the report,
the report appears to be quite voluminous, and this is raising doubts in the mind of the court. I have not gone through it, but the volume speaks a lot.
They have done voluminous, but my lord, can you see my exception is very.
You do not have anything to say.
I have something to say. Lordship, can you see only 3 paragraphs I will have to show to my lordships for exception. Kindly see, let exception be taken, my lord. Exception and report is side by side. Lordship, kindly see, I have written. We have
First, you show me as to why affiliation was not given. You show me that.
That is not an annexure. One minute.
E12, my lord, page 56 of my writ petition.
Yes.
Status of affiliation for the academic session 2020-26. Previous to that, PCI has already been given affiliation that I have already been annexed. Versus kindly admitted. The council arranged inspections of your institute to assess the available resources and other things. However, it has been observed from the inspection report of our institute that there are following major deficiencies. Disputes in the infrastructure and other facilities required to conduct the course. This is infrastructure, model pharmacy, etc., etc. Laboratory infrastructure, equipments, etc. Lots of 3 faculty. These 3 deficiencies, we have made application for reconsideration. That is annexure T13 and onwards. We are not giving all copy that we have no deficiency because in the previous 2 sessions, my lord, on the same intake of 60 numbers students, they have given affiliation and approval. On the same count, my lord. Our lordship shall see, there are my lord lordships going through the same. The coordinate page directed to file a report. Lordships kindly, this page should be open. 57. And lordships kindly take the my exception and the report side by side.
Yes. Yes.
And in page 6 of the report, there are 5E. That is, I have stated in 7.1. My exception, page 3. 5E, lordships kindly see that in cases of minor deficiencies, the council had earlier granted, kindly marked it, granted provincial and affiliation, allowing time for rectification.
Yes.
Now, my lord, kindly come. R1. That is R1 of my exception. That is first annexure. Page 9.
Yes.
Got it. That is 16th January 2026. The order. The council arranged.
This is not in respect of this college.
My lord.
Which college? What is the name of the college?
Chandra Kumar Das Institution of Education. Second line.
You are Bengal Education of Pharmacy.
Bengali, but how they have given.
Oh, in respect of a third party.
Third party. That is, I have only 3 institute. Lordships kindly see. Status of affiliation for the academic session 25-26. The council arranged inspection of an institute to assess the available infrastructural and other facilities to conduct the 2-year diploma in pharmacy course to an institute in the academic session. However, it has been observed from the inspection report of your institute that there are following major deficiencies of the dispute in the infrastructure and other facilities required to conduct the course. Lordships, these are all are disputes. 1, 2, 3, 4, 5, 6. Lordships, only I have, in case of me, only 3 deficiencies are there. In case of them, my lord, 6. Even then, LR document is also false, my lord. It has been written there. Subsequent thereto, in view of the above, the council declared. So they are withheld. Next page. Page 11, my lord. Lordship got it, page 11.
Provisional affiliation.
And this. When 18th March 2026. And even then, that has not been rectified. We have already made representation, rectified all things. What they have stated, they have not considered in our case. But in case of that, they have given, not in case of one. Lordship, kindly see the next page.
Gurukul Institute of Medical Sciences.
My lord, next page, my lord. Gurukul Institute of Medical Sciences. Same thing. In view of the above, the council decreased here, my lord, 1, 2, 3, 4, 5. Things has not been followed in case of us 3 only. Now they have next page, my lord. Not only provisional, they have been given approval on 9th March 2026.
Ilam Bazar Institute of Pharmacy.
Next, my lord, Ilam Bazar. And Ilam Bazar, same thing, my lord. And they have given also approval. Now, my lord, kindly come to another aspect of the matter.
Yes.
Now, paragraph 8, my lord. Exception 6 page.
Yeah.
Page number 11 of the report, Lordship, can you see?
Page number 11 of,
11
the,
of the
report.
report.
All right, 11 of the report.
Point number 15, ma'am.
15.
These type of reports have been received by the council from 67 college institutes, the affiliations of which have been withheld for academic session ato. Out of those colleges, nearly 57 colleges institutes, including the petitioner institute, submitted a report at their own volition, claiming thereby rectification of the deficiencies. To check the veracity of such suo motu reports, an expert committee was formed. Can you see? But who are in the expert committee? That has not been stated. Who are the members? I have stated, my lord. It is apparent on the face of the record that an expert committee was formed, but it has not been stated and informed the petitioners when the said committee was formed, who are the members of the said committee, how the said committee has been considered, either by taking any resolution or by any executive order. Then report proceeding of the committee have not been disclosed in public domain. So it is clear that there is not only that, my lord, also kindly see point number 16 at page 11 of the said report.
Yes.
Point number 16, my lordship, got that expert committee examined the compliance reports and compared it with the available records and first SIF of each of the different college institutes. During such process, in respect of only 14 institutes, the expert committee opined recommended to cause reinspection. And in respect of other colleges institutes, the expert committee with detailed disease did not recommend it and reinspection. In compliance thereof, the inspection team inspected such 14 institute colleges. And based on such reinspection, it was decided that only those 14 colleges can be accorded with affiliation for the session 2025-26. The petitioner institute, based on their nature of deficiencies, was not recommended as such, and decision of withdrawing affiliation for the academic session approved. Now, the expert committee decision is there, my lord.
Is it annexed?
My lord, yes, page 129. Annexed A. Lordship, before that, lordship, kindly see only one thing. What I have stated about that. Well, expert committee chooses only 40 institutes. Page 7, first line, in my exception. Chooses only 14 institutes to cause inspection, and how the said 14 institute has been selected, and the names of the institutes who have been so lucky to be chosen for inspection and given affiliation have not been disclosed. And whereas the petitioners were excluded, and after inspection, that 14 institutes colleges has been accorded affiliation, depriving the petitioners therein, which is kindness. Only they have taken chosen 14 institutes, they have given affiliation. Not in our case, they are not chosen us, nothing. And the deficiencies also they have mentioned, even then they have given affiliation. And not only that, they have given affiliation in the month of April also, 2026. And in our case, they
the course started in 2025. When? in maybe June, July, August, when did the course start? At what is the session? Where is the work? At what time that
I'm cutting it short, madam. My learned friend was saying a lot, but we need to know the backdrop, madam. Till 2022, there was a moratorium. Due to mushroom growing of pharmacy colleges, in West Bengal, we have seen a strange thing, PCI, that all B.Ed colleges were being converted into pharmacy colleges just with a banner. Subsequently, moratorium was imposed. Subsequently, the moratorium was withdrawn, and
when was it withdrawn?
2022.
It was imposed on
5 years moratorium was there.
21, 22, it was with.
5 years moratorium was there.
All right.
After that, what happened? PCI, they made a mechanism. COVID period was also there. After that time, they made a mechanism that okay, firstly online inspection will be there. Subsequently, physical inspection will be there, and they used to grant permission, provided that we must understand how things works. Firstly, PCI grant permission. Let us take about law. BCI is the authority, Bar Council of India, gives permission to a particular college. Yes, you can start a law college, but that particular law college needs to take affiliation from any university. Here, the role of PCI is just like BCI. They give approval, but the ultimate examining authority, the state authority, or other 3-4 boards or 3-4 authorities are there. So at that time, one PIL was moved before this Honorable High Court.
tell me one thing. Do y'all also have expert members?
Yes, we have.
You have. All right. Yes. Now make
One
submission.
PIL was moved before this Honorable High Court. This Honorable High Court pointed out, yes, some serious things are happening, and some colleges are getting affiliation in spite of having no infrastructure. This Honorable High Court directed the state authorities, you can cause inspection, regular inspection as per your own choice. It's something like my learned friend was saying that we have chosen, they have not chosen. As per so far my understanding is something like income tax scrutiny. Something like income scrutiny abrupt. So all this thing happened. Few institutes were chosen and they were checked and they have cleared few institute and they stopped few institution. Now it's a case of 2000 admission of 25-26 batch. The case was filed in March 2026. We are in end of July 2026. The course has progressed. PCI has already started giving affiliation for the next year. So with the state authorities. I'm asking the question to myself, what will be the future of these students if they get admitted right now, or if they start course right now, or if
No, admission has already been done
February
possibly.
2026.
without approval, my lord.
Only February 2026.
Without approval.
Only we are in July, from February till July. What happened?
Lordship, can you see? Immediately we moved this writ petition. February 2026. April also they have given application.
Yes.
Student registration.
And few cases were before the earlier.
Students registration has not yet been started.
Before
and the next matter, Lordship, we'll get that information that in the month of February there was a notification of them.
Before.
What does that notification say?
My matter, my lord, they had conducted a spot council for filling up the vacancies which are to be filled up by the management. Lordship, those notifications are annexed in item number 6.
Your college has also not been granted affiliation.
My case, my lord, it is affiliated already.
By the pharmacy council, not by the vocational.
It is already given, my lord. What has happened in my case, during the time of the inspection, they found certain deficiencies. Deficiencies were notified. We have fulfilled the deficiencies and immediately we have intimated. In the notification where they have indicated there are the deficiency, they said on the basis of the deficiency, the recognition will be withheld without prejudice. So that was given. So I have fulfilled it and I made a prayer for the reinspection of the college. I want
It is at that stage.
At that stage.
All right. What I am thinking of is.
And not only that, PCI subsequently already given notification for 2026-27.
Yes.
Inspection was also made.
All right.
There also we have passed.
All right. What the court is thinking of is directing the authorities to conduct joint inspection. They will go over there, they will inspect whether there are deficiencies or not and file a report before this court.
Including these 14.
All. And if there are deficiencies, the affiliation will be cancelled.
Including these 14.
All.
My scope should be enlarged. For PCI and scope should be enlarged, and that should be in respect of all pharmacy colleges. That's my humble submission before your lordship. Because I know what is happening. Even PCI got the idea. Which
Everybody knows what is happening. Why 5 is chosen and 10 not chosen?
there should be a full inspection and a
Everybody
report.
knows it.
My lord, and in respect of this particular college, my lord, the inspection report, it depends completely on the expert committee.
Yes, yes.
29.
Now let us know who the experts are and what is the report.
One also appearing, page 131.
Maybe.
Yes.
Maybe. Let us see.
Only 14. They have, my lord.
How many total colleges are there?
67 most probably.
Total colleges all over West Bengal, it is, my lord, more than 100 or 200, because from 2021 that private colleges have started, my lord, seeking affiliation.
It is the private ones which you should first go and inspect.
Maximum colleges are in Birbhum, my lord.
In Birbhum.
Maximum colleges are in Birbhum.
No, in my case it is Murshidabad.
What is this?
There was public interest litigation also filed.
Yes.
Yes.
The live streaming is particularly on so that everybody gets to know what is happening.
Yes,
my lord. This is the
It's
Yes.
Birbhum adjacent to Murshidabad, then Nadia. All 3 districts. I never seen so many pharmacy colleges. All were B.Ed colleges and converted into
How
pharmacy
many?
colleges.
3 districts. Your is which district? Howrah. And the one that is being moved is Murshidabad. Right? All right. In
It
these
should be in
districts,
respect of whole West Bengal, my lord.
whole West Bengal, I'll come. These 2 districts, since they are before the court, please come. The petitioner is a pharmacy college institution imparting education in, what is the course? Name of the course?
D Pharma.
B Farm.
Diploma in Pharmacy. Stop. Allegation is that despite removal of the deficiencies pointed out by the West Bengal State Council of Technical and Vocational Education and Skill Development, the authority is deliberately and intentionally withholding affiliation for the course 2025 and 2026.
It should be renewal of
Renewal of affiliation.
All are running colleges.
Not renewing the affiliation. Stop paragraph. It is the specific stand of the
This
council.
specific term was used was withheld for the academic session 25-26.
Yes.
The specific term that not given.
Not renewal.
Not removal. It was either the withheld for academic session 25-26. Page 56 of the writ application. I don't know in respect of that matter.
You must be having the brief.
My lord.
You must be having the brief of that matter.
Item 5.
6.
6, yes, 6.
Yes. ठीक है तो withholding affiliation of the council that the affiliation could not be granted because of the deficiencies that have been pointed out to the pharmacy institutes. Stop paragraph. It appears from the submissions made on behalf of both the parties that the course in question started from February 2026. Stop. There is a requirement of ascertaining as to whether the institutes does actually have the requisite infrastructure to impart the diploma in pharmacy education. Stop. The students who may have taken admission in these institutes may not get the proper education if the institutes do not have the requisite infrastructural facilities required for running the course. Stop. According to the Pharmacy Council of India, there are several pharmacy institutes which have mushroomed in the various districts of the state. Stop. The petitioner has pointed out that there are several institutes. The petitioners, petitioner হচ্ছে এই মামলাটাতে বেঙ্গল ফার্মাসিটাতে। The petitioners have pointed out that there are specific institutes which do not meet the requisite criteria for affiliation and have not complied with the deficiencies pointed out by the council, despite the same, the council proceeded to provide affiliation to those institutes for the academic session 2025-26. To ascertain as to whether the institutes actually have the infrastructural facility to provide, to impart education in the subject course, an expert committee ought to cause spot inspection of the subject institutes. Stop paragraph. The Pharmacy Council of India and the West Bengal State Council of Technical and Vocational Education and Skill Development are directed to constitute a joint committee and proceed for joint inspection of the petitioner institute and also about the institutes whose documents are annexed in the exception filed by the petitioner. And submit a report before this court as to whether the institutes have the infrastructural and other facilities for imparting education in the subject course. Stop. Such inspection, the committee shall be constituted positively by 22nd July, 1 week time I have given you. And the inspection shall be concluded by 12th August. Release the matter on 14th of August. 2 weeks time.
2 weeks time.
Only one thing, my lord.
Instead of 1 week for constitution of the committee, and I'm asking for 2 weeks, my lord. It is possible.
We have already got NOC from Faculty Council. We will leave West Bengal State Council of Technical and Vocational Education. That's why we have already prayed before the West Bengal Council of Technical Vocational Education for giving us
you want 2 weeks?
For giving us permission. That permission is also not being given.
Today is 15th. So in that case, 29th of July. And 1 minute. Of 15 থেকে 29 তো তাহলে ইন্সপেকশন করতে 2 more weeks it will go up to the 21st of August. Two weeks will be difficult for giving you time. ওটাকে 29th করা যাবে না. Make it 24th of July. 24th of July. And the inspection shall be over by 10th of August. Release the matter কবে বলেছিলাম? Let it remain on 14th. You give 2 more days. 12th of August, the inspection should be over. And 14th. ঠিক আছে? আর pendency of the writ petition and the inspection will not stand in the way of the authority to provide affiliation to the college, to the petitioner institute, provided all the infrastructural facilities and other deficiencies are cured by the institute prior to the adjourned date.
Only one problem. Is the intact.
I
have specific.
I was searching for one notification. I wasn't getting. Somehow got that. But notification of PCI issued in May 2026. I would like to just place 2 paragraphs, my lord. Whether this inspection by the state authority, whether they have the authority or not.
Then there was one document which was
Yes,
short.
we have already replied to that. That is a PCI document, but that was done.
But then your members will also be there.
Yes.
File separate report.
Which
No issues with that.
That was in
And only one thing.
One thing, my lord, may I just submit that PCI's letter was given, my lord, based on the other 2 high courts' decision. But in our high court, the Honorable Chief Justice, then Chief Justice, my lord, there is a specific direction upon us in compliance to that this reinspection was done for the academic session.
All right, you say you have the power to inspect. Both of y'all will go together, but reports will be separate. It's not that joint report is to be filed.
Yes.
বললাম না, file reports, separate reports করুন and file separate reports.
And in that case, my lord, that as of now, then next year for 26-27, PCI has given my lord notification for new colleges for the new academic session. Affiliation, not new colleges, the affiliation for the new session.
And we have already got that affiliation.
But 25-26, we are on the verge of completion. And as of now, even if we find that the colleges have made up all these deficiencies, but for this session,
First go and see.
First
go and see whether there are students, whether there is a college or not, because I see a document which is annexed in the exception that there is no college. There is some building, photo of some building shown as a pharmacy institute.
Yes, that is.
This is what the petitioner has annexed.
May I say just one thing, my lord? Everything was not, my lord, appraised to your lordship.
Maybe you first go.
Yes,
you see what is there.
Yes.
File a report. And then we'll see what is to be done.
Then
yes, what is your submission?
Students were already admitted under the management quota, madam.
How can they?
Let their registration be continued.
No. How can they?
Let us see. Let the inspection report come.
Only one thing.
Otherwise, these students will face problem if the college, if the institute is not affiliated. How can the registration come?
Approval and application, no student can be admitted.
Only one thing I should. My lord, only one.
Your lordship is keeping it on 24th of July. So
No, not 24th. It's 14th of August.
14th of August. In the meantime, they should not start the registration. Then it will be. It has not.
Over.
My lord, only one thing. Otherwise, lordships on the next day will may say that I have suppressed some facts. My lord, I prayed for de-affiliation of the pharma course from West Bengal State Council of Technical and Vocational Education for the year 2006 and 2007, and we will go to the faculty council. We will not with them. So lordships, they have,
Stay with the
but they have not yet, but they have not yet relieved. They have not yet given us relieved. They are not relieving me. That is also.
In short, management quota is important.
Very important. Acha, ekta jinish, exception.
Only this much is may be recorded.
Filed by the petitioner to the report filed by the council in court today be written with the records.
One thing, this might be important. That we have rejected, withheld. They have suo moto all these colleges. Many years, 57 or 67, they filed that we have cured the defects, reconciled. For that, the expert committee was formed. They have inspected the documents. They have opined that in respect of these 14 colleges, you can re-inspect. Then re-inspection done on that basis, the affiliation was given only this for a limited colleges. This is the
Yes. A limit college means everybody knows what is the limit.
limited college means out of 67
without prejudice. So therefore, I have
out of 67 we have allowed, we could allow only 40 based on the expert committee's opinion.
Because the 14 was able to satisfy your demand.
That was not the case, my lord. It is
My lord,
because the
my lord,
question came up.
my lord, only
Came up.
only
This
the
question came up because the allegation may be, well, it is very easy to put forward these allegations. But the expert this even page 139.
All right.
my lord,
Please conduct a further
my lord, only
inspection
my lord,
and let us see what happens.
But it depends on what on that basis of that inspection they are.
All right. You bring that this has been cured. It was not there on that day. Whether it has been cured or not, let us see what the picture is now.
Consider for the next academic session.
Very well. You say that also.
no. We have prayed for de-affiliation.
They do not want affiliation.
From 2027 to 2000, these document may be in the record, my lord.
It is our specific.
My lord, these record may.
Same
Excellent.
order will go down in item number 5.
6.
6. আচ্ছা item 6 exception টা হবে না আর ওই জায়গাতে বলা হয়েছে না যেখানে যে the petitioner has annexed documents in respect of other colleges সেইটাও হচ্ছে না ওইটাও হচ্ছে না কিন্তু ঠিক আছে এক্সেপশনে যেটা বলা আছে
These document may be in the record, my lord. I have prayed for de-affiliation.
File it by way of an affidavit. They will also get to know.
The lordship is allowed for directly for the joint inspection.
Yes, the inspection will be conducted. আর কিছু পাস ওভার আছে আর্জেন্ট মোশন
Number 10 from the delegate.
My lady, I'm appearing for the petitioner.
Yes.
May I file my exception, my lady? Your ladyship, along with it, I have also filed an application for urgency and for modification of your lordship, of your ladyship's order. My lady, before placing anything, may I place the order of the Honorable Division Bench passed on 31st March 2026. My lady, kindly sees page number 2 and page number 3, my lady. Why am I showing this? Because when I approached the court, I am with electricity, but alleging their challenging their 2 notices, which was illegal. Your lordship, Justice Kapoor has listened to this matter, heard this matter, and after this, your ladyship, that matter was dismissed, and I went to the division bench. Honorable Division Bench on 31st March has passed an order and said that regarding factual aspect, you have to file a review before Honorable Justice Kapoor only. And I have filed, so my review application is pending. And regarding illegal disconnection, that was happened after passing of that order. The order of Justice Kapoor has passed on 20th March, and disconnection happened.
Do not go into all these things. You want electricity, certain formalities is required to be complied with. Why don't you comply with? They are ready to give electricity.
My
to
lady,
you.
I have already applied for the electricity name change process.
Show me.
My lady, kindly sees my exception dated 22nd, exception to 22nd May.
Why 2 exceptions?
My lady, they have filed 2 reports, one before you and one before Justice Kapoor in the same matter, my lady.
All right.
The 22nd May, I have annexed report against 20.
Which affidavit to be seen? There are 2 exceptions.
Not the 4th May, your ladyship. It's
22nd May.
Yes, ma'am.
All right.
The last page, kindly sees.
Last page, yes. Successful submission of change of ownership application.
And
from W, your application has successfully submitted through. And you've done it only on the 8th of June?
Yes, my lady. As per
the order was passed long back prior to the summer vacation. Why did you wait for 8th of June?
My lady, because there is a problem, my lady. They are not accepting their web portal. They are not accepting. I have went to their office and they have not accepted any documents. After this, I have to file.
Everything has to be done online.
Yes.
Why will they accept documents over the counter?
Yes, my lady, that has to be, that was done. But they are not accepting this. They are saying that I have not applied. It is their submission on 9th June, my lady. They said that I have not applied.
The respondent authority is an Article 12 authority. You are an individual. There are several lakh of individuals who are getting benefit from WBSETCL, right? Why will the authority behave like this with you? There is absolutely no reason.
As I told you, ladyship, earlier, that because of my complaint regarding illegal connections in the locality.
Illegal connections,
whatever
they
it
will
may
be happy to disconnect.
My lady, whatever it may be, but they are hand in gloves with them. But whatever it may be, my lady, there are 2 separate proceedings. One before review court, that is before Justice Kapoor, and one before your ladyship regarding disconnection. That disconnection is illegal, my lady, and the division bench, honorable division bench, has directed me to file a separate proceeding for this illegal disconnection. And regarding the name change process and all, with most humble submission, my lady, that has to be heard by Justice Kapoor. And my lady,
that means you do not want relief from the court. This is your primary contention.
My lady, I have prayed for the connection. I have prayed for the reconnection. Yes, I am asking for the reconnection.
Your writ petition was filed long back, and it is only for your insistence that you are not getting connection.
No, my lady, that I need to show you, my lady. Kindly
Nothing to
see.
show. The court can very well understand what is going on.
My lady, I have applied for the name change. I could not understand why the authority is doing like this. But
what is the problem?
Kindly see.
My lady, kindly sees the one
Let her
minute.
complete, otherwise I cannot.
My lady, kindly see the writ petition I have filed before, my lady. May I kindly show the notice dated 23rd March 2026? That is page 53 of the writ petition.
Yes.
My lady, this notice is itself illegal because this notice has to be served 24 hours before inspection. They asked for the inspection and they said that I have not allowed the inspection, but that is wrong. But even after their inspection, admitted inspection by your ladyship's order on 20th May 2026, they have connected the supply, did the inspection, and after that disconnected the supply. But nowhere in the law, your ladyship, it is provided that my connection should be disconnected only because of name change process or anything else. Even they have LS section 163 of the Electricity Act. My lady, may I kindly show you the Electricity Act section 163.
Right. Let us try to understand what the authority has
My
got
lady,
to say.
let me place one law.
No,
My
no,
lady,
do not place
even
any
before
law.
vacation, my lady, you said that after
Please do
vacation you
not.
place.
Please do not.
My
Yes.
lady,
What is it?
This is a very unfortunate case.
Why
Your
is
Lordship, I tell you,
electricity-
Lordship. I tell you, Lordship. But there are three things. First of all, the petitioner before your Lordship is not our registered consumer. And so far, the application which has been placed before your Lordship, kindly see the color of the application, what they have done. Kindly see in the exception.
Exception.
Yes. Now they are saying they have made an application for transfer of name. Kindly see. First page of that application, what are the enclosure to be made?
Page 17, are you referring to?
Yeah, my Lordship, I am from the soft copy. I don't.
Yes.
Pagination has been given to me. So
All
for
right.
the yeah, that is the annexure. That is the.
Is it the application with undertaking?
Yes. Lordship, kindly see the enclosure for change of ownership.
Yes, enclosure. Photo.
Whether they have given it or not, kindly see. Nothing has been given. Only the signature has been given. Nothing. I have the officer and I have repeatedly requested her to go to the office with all documents. Officers are there, though it is not the work of the officer. Officers are there to help them to produce the documents, so far the affidavits, succession certificate, whatever is there for change of name. Nothing has been produced till date. And your Lordship, kindly see the order passed on 22nd of May 2026. I am drawing your Lordship attention. Where your Lordship was pleased to direct him that after inspection.
Did you intimate the petitioner that these are the deficiencies for
Yes,
which?
Lordship, kindly see in the report itself I have specified. In the report, kindly see passed
But
on.
then the report was prior to her filing the application.
Yes, prior to filing on that, so they are well aware about it. That
No, after page 17 is submitted and page 19 you have mentioned that application for change of ownership has been successfully submitted on 8th of June 2026.
that is on online application,
Online.
but it has been made. The application can be successfully submitted. Whether it is in proper form or not, that is to be verified.
Why don't you verify and communicate the petition?
But already it has been, I have been told it has already been communicated to them, specifying that it is not in proper form. You have to give these other documents. Till date, nothing has been given.
Show me that you have communicated.
Then I have to see that whether it has been communicated. It has been communicated, Lordship. I will, if your Lordship give us the time, then I will put it in on the next date.
My
And
lady-
what happened, your Lordship, kindly appreciate the situation. That meter is not in the name. There are three issues. Kindly take into note. I am here to resolve the issue. There are three issues. One issue is that the meter is in the name of a dead person. We have requested them that on the several occasions we have tried to make an inspection because we are not getting the meter reading, and we have given a notice in the writ petition. If you also kindly see in the last page where the letter is there, where we have issued, and your Lordship has given the observations on the order dated 22nd of May 2026, where it has been specified, in spite of giving several notice, that they haven't changed, they haven't taken any concrete steps, and we haven't given any access to the meter board. Now, on that basis, this matter has been taken up by the Honorable Justice Kapoor, and his Lordship was pleased to say to disconnect the meter if they don't fail to give the inspection. We have made an inspection, we failed to get access to that meter board, and we have disconnected the electricity. And this notice, not for 24 hours, we have given notice 15 days, 20 days back. Your Lordship will find from the notice date. But we are not getting any sort of cooperation. There are, your Lordship knows, there are thousands of, almost 1 lakh consumers
It is not possible for us to ascertain, and there is no, I will say, no allegation against them. Only we are there to help them, but they are not standing on the way. Secondly, we are not getting access to the meter board. Thereafter, when in pursuance to the direction given by your lordship, we have gone to the for giving inspection.
And you all had to face
Yes,
harassment.
yes,
You all
and
went to
we
the
have got the
police
videograph
station.
also, and we have to
Right.
guess. And on that basis, your lordship was pleased to direct them that immediately you make change of the name 3 times. This order has been passed, but till date, no application has been made in accordance with law. And your lordship, in the report itself, it has been specified how the application is to be made, but nothing has been done till date. And lordship, kindly see, they are saying that I have said the 3 things. One, change of meter. Secondly, we have says that access to the, and if you not get, we have also in the report we have specified that if you do not get access outsider and it is technically feasible, it will not harm to anybody and it will not disturb their right of privacy. We will get the meter reading and we will go there. So in spite of that, they are not cooperating with us. One thing they have to do at this juncture, subject to your lordship kind approval, they can apply either for transfer of name, or they could have surrendered that meter and can apply afresh if there is any problem relating to the transfer of name. I'm not delving into this subject, lordship, though I am aware, but I'm not delving in. If they are not in a position to transfer the name with all corroborative document to substantiate the statement, then on that basis, they could have surrendered the meter and can apply for fresh meter. We will give the fresh meter, subject to compliance of all other formalities. And secondly, fresh meter is to be given, and it is to be given in the outside of their house. Otherwise, it is very difficult for us. We have got several consumer, we cannot.
Right.
And secondly, lordship, kindly see, they have given several aspersion. Lordship, I am not going into that aspect. Lordship, kindly appreciate it. For a several occasion, this matter has been taken up.
All right, let me hear.
Yes.
Yes, the application that you filed, that you have annexed with your exception, is an incomplete one.
My lady, I have submitted all the documents also. Regarding affidavit, my lady, the petitioner is very ill. She could not move, my lady. And regarding that, the death of the original consumer has already been admitted by both of the parties. And even an illegal occupier can get an electricity connection. At first, they have asked for what is the jurisdiction
You
of my lady.
want a new electricity connection? You want change of ownership?
My lady, I want reconnection of the electricity connection. They have
the earlier one. That is the earlier one. That is the earlier one.
Is the earlier. My lady, kindly sees the notice. The
1
notice
minute.
has to be.
The person is no longer there. The consumer in whose favor the meter is standing is no longer there. You are not a consumer.
My lady, kindly let me submit.
No,
My
no,
lady-
sir, no.
my
The
lady,
court is not going to accommodate you to that extent. Enough has been, enough
My lady, I
leniency
was
has
not
been
heard on
shown.
this point. I was not heard.
You are not required to be heard. You want relief. Why don't you accept relief?
My lady, I want relief, my lady, but 1999, the original consumer died. After that, they are accepting payment from me. They have, my lady, even after disconnection on that ground. After that, they have released the bill. Until June 2026, I have paid the bill.
You are without electricity. What bill are you paying?
I have paid the bill.
What bill are you paying?
My lady, kindly sees.
It must be only the
Prior to that, prior to this,
old bills, the area bills.
After disconnection.
kindly see the letter which has been in the writ petition, page 52 of the writ petition, page 52.
My lady, I have annexed this document while doing the appeal. My lady, it's the page of the appeal.
You cannot annex documents appeal court for the first time. You have to first show it to the writ court and then you
My
can
lady,
go in
before
appeal.
vacation, in the vacation, my lady, I have went to the vacation bench regarding.
Then it's up to you.
My
The
lady,
document is not there on record of this
my lady,
court.
kindly says April to June, the bill they have issued after disconnection, and I have paid the bill. So I am a consumer. I'm an implied consumer.
No, or implied consumer. Under which provision of law
My
you are
lady,
coming with all
under
these
which
things?
provision of law they are
You
entitled
have to. You firstly, why don't you follow the law? Make the application
My
in,
lady, I have done
accordance
so.
with law.
There is a guideline of them that everything has to be done online, and I have done so.
Where is the photograph? Only a photograph, a photo identity card.
My lady, kindly
and under
sees.
the affidavit is
I'm
required to be
showing.
given. Why don't you give that and get it done?
I have done so. I have submitted.
Where is the affidavit?
I have sent the.
Where is the affidavit?
Not the affidavit.
Then,
but
a
the
part compliance.
No,
Where
not-
from part compliance will the act?
My lady, not the part compliance.
Then what?
Kindly listen to me.
You have to file. There are the enclosures mentioned in the application form.
Whatever documents they have been asking, it is not the mandatory
Affidavits.
one. It is not the mandatory one, my lady. My lady has to.
What is the problem? Why don't you either you take a new connection
in my
or you continue with the old one with change of ownership along with the documents that are required?
My lady, I have done so. Even if that, it has to be decided by Justice Kapoor, my lady. They have illegally disconnected the supply, my lady, on that point.
The matter has been assigned before this bench.
My lady, not that. Review is always been with Justice Kapoor.
Let the review be done by Justice Kapoor. Where is the problem?
So that notice, which
in that case, I dismiss this writ petition. You again go for appeal. That is better for you.
My lady, but this disconnection was done as illegally, without any authority of law. My lady, kindly seize my writ.
All right, I'll fix up the matter for hearing.
My
Whether
lady,
it was
my lady, kindly
done
seize-
illegally or legally. The
My
court
lady,
will hear.
kindly seize page number 53 once.
Yes, I have seen
Page
page
53 once, my lady.
Exception.
My
Take
lady,
down,
kindly
please.
seize. My lady, I'm praying for urgent reconnection.
Exceptions. You cannot get reconnection till you act in accordance with law.
My lady,
you are not acting in accordance
But
with
my
law.
lady, nowhere in the law provided that if you are not doing the name change, you are deprived of the electricity. That is the
Exception.
administrative process, my lady. And I have applied
Exception.
so.
Filed by the petitioner to the report filed by
My
the
lady, then
respondent authority.
kindly dispose of the writ petition, my lady.
Without hearing.
My lady, kindly hear.
Without hearing.
My lady, petitioner is seriously ill without electricity. I'm without electricity.
It is for your
since March.
fault.
How, my lady?
Deliberately, it is for your fault. I do not
If
know.
I may ask this question to myself, page 53, kindly seize once.
In court today, we retain with the records.
Illegality has to be decided by your ladyship.
Yeah, just stop. It appears that the learned advocate for the petitioner stresses on the fact that application has been made for obtaining, not obtaining, for change of ownership of the existing meter. Stop paragraph. Learned advocate representing the respondent authority submits that the application which was made in the online portal is without the necessary enclosures as required under the law. Stop paragraph. Learned advocate for the petitioner admits that the affidavit required to be submitted could not be submitted as the petitioner is not keeping well.
Here she has come for making affidavit here and not.
Subject matter, it is the subject matter of review, my lady. Kindly note that.
What is the subject matter of review? You make application is the subject matter of review.
My lady, this is the subject matter of review.
I don't get it.
My lady, for once, kindly seize order dated 20th March.
Stop.
31st March.
I fail to understand. I am making all sort of cooperations.
No
Very
cooperation at all.
unfortunate.
Only the enmity they have
But
they
what
are
sort
doing.
of? We have got thousands of consumers.
And hand in gloves with them regarding illegal connections.
The notice dated 23rd of March 2026. Annexed at page 53 of the writ petition is impugned herein. Stop. The validity of the notice has to be adjudicated upon hearing both the parties.
My lady, kindly hear me today, my lady. It's a very short matter.
List the matter for hearing on 17th July 2026. Stop. It will be open for the petitioner to comply with the requisite formalities in accordance with law for change of ownership of the meter.
But today we are on 15th.
Yes, day after
17.
tomorrow, so that the petitioner may get reconnection of the electric meter. Stop. The paragraph there. It appears that despite repeated opportunities granted to the petitioner for compliance of the necessary formalities,
Only once.
for changing the ownership of the meter and to provide access to the meter for the purpose of obtaining reading, comma, the problem still persists. Stop. The specific stand of the respondent authority is that the petitioner does not provide access to the electricity board, for which it becomes absolutely impossible to collect the meter readings and the electricity bills cannot be raised. Arecta paragraph. Pendency of the instant writ petition will not stand in the way of the petitioner for obtaining fresh electricity connection in accordance with law. Day after tomorrow you come?
And then if they have
My
to
lady.
make a fresh applications.
In accordance
in
with law, they can always.
My lady,
you
I have
not
already
stand
made.
in the way.
My lady, I have already make an application regarding modification of your ladyship's order. Kindly don't make any observation, adverse observation, my lady, kindly.
Call the next matter, please.
11, my lord, I beg to appear for the petitioner.
Yes.
This is the matter relating to CPF to GPF, my lord. The petitioner retired from service in the year 2004. After that, my lord, the larger bench has passed order in 2014. Thereafter, petitioner made representations to the authority concerned, my lord, for changing of his option. Now that has not been considered. Now kindly see.
There is a communication from the District Inspector of Schools. Right, page 16. There are certain papers which are wanting from you. Where are those papers?
No, this is a common order. Just
to the head of the institutions.
I have annexed. This is a common order. It is of 2022. My lord, thereafter I made representation. My lord, kindly see page 13.
Which page? Yes. You want consideration of your representation?
My lord, not only consideration, the
Pension from the date of retirement.
from the date of retirement.
When are you, from when are you getting the pension?
I am not getting pension.
Are you entitled to pensions?
I am covered by the judgment of the larger bench, as well as considering the larger bench judgment, honorable division bench, two division bench has covered that those teachers, my lord, who retired prior to pronouncement of the larger bench judgment of 2014, they are entitled for pensionary benefit if they exercise option in terms of ROPA 1990. I have exercised option ROPA 1990. I have intimated the authority concerned that I want to.
Where is the document to show that you exercise? Are you getting the benefit under ROPA 1990?
Yes.
You are
For
getting.
that reason, my lord, I retired in the year 60 years. Otherwise, my lord, I would have retired in 65 years. I retired 60 years. That means, my lord, I exercised option ROPA 1990. And division bench has said that if anybody exercises ROPA 1990, automatic shifting from CPF to GPF.
Yes.
However, only intimation is required to the authority concerned that I want to refund the provident fund.
Then there are several orders passed by this bench also. Give me any of such orders which will cover you.
And your lordship's order has also been affirmed by the honorable division bench, but very unfortunately, your lordship's order, I did not get. But your lordship's order.
Bring. I have passed several orders. I'll make it not today, not this week. What you want? Bring orders and I'll see.
Prior to that, only difficulty I am facing. And other matters, my lordship has passed order And those persons not exercised option in the year 2014 within the stipulated period.
No, no. Even in respect of those who exercised option, in
Right,
respect
right,
of
right.
1990, this order is also there.
Day after tomorrow.
I can keep it next week also. You get the weekend.
Monday. Monday.
Monday? All right. To allow the learned advocate representing the petitioner to come prepared, comma. List the matter on 20th, Monday.
For the petitioner. Your Lordship, kindly remember in earlier those, now the colleges 11, 12 classes were there. And the teachers were appointed for that purpose only. They were the teachers of class 11 and 12 in a college. The case is such a case. Malad, kindly have a look to page 17. That's my appointment letter.
This is a 23 matter. It is still at the motion stage.
Yes, Malad, yes.
But I've just received the papers today, my lord. I will. Subject what falls.
And this is a pension matter.
He is getting pension.
He is getting.
But the rate of pension is
76 to 80.
yes.
Huh?
For the length of service, the proportionate pension.
Yes.
So he is claiming it's from 76 at least because that was the date of appointment. Subsequently, there was a pay fixation. Now the authority is granting him from the day of pay fixation.
All right. So the past service is not being taken into
Yes,
consideration.
yes. I have certain judgments to show before Lordship. If my learned friend is ready,
Is there an order of refusal which you are challenging or anything?
yes.
Page,
That's
is
there.
it page 39? Reason
That
noted?
is page 39.
What does it say? Please place it so that your learned friend gets to know what exactly
My lord,
instruction he is required.
kindly have a look. Kindly come to page 40. The decision with reasons. The grievance ventilated by the petitioners in Naran Chandra Ghosh, retired selection grade lecturer of so-and-so, Birbhum, in his representation dated 1st of April 2013, is that his entire service period from 76 to 2009 was not counted in computation of the total qualifying service, and as such he has been denied of full pension benefit. The petitioner will be entitled to full pension benefit if he or she renders 33 years of service. The quantum of pensionary benefit will proportionately decreases if there is shortfall in the requisite length of service. The requisite length of service had fallen short because his past service in the college from 76 to 1980, so 4 years, was not taken into consideration in computing the computation of qualifying service for the petitioner of determination of pensionary benefit. In the instant case, the qualifying service was counted from 1st of December 1980 and not from the 15th of July 1976, as it was done in respect of all other graded lecturers who were allowed the scale of pay of rupees so and so from 1st of December 1980 by virtue of Education Department government, that is there 6th of January 81, which had also the concerns of the Financial Department. From the materials made available to the undersigned by both the parties at the time of hearing, it appears that Sri Naran Chandra Ghosh, the petitioner, was appointed by the college authority as a whole-time lecturer purely on temporary basis in the higher secondary unit of so-and-so Mahavidyalaya commerce section in the scale of pay of so-and-so with effect from 15th of July 76 on condition that he would be entitled to pay scale as and when it would be decided by higher secondary council. From this information, two important features emerges. In the then college of the state, there was a distinct and separate higher secondary unit, and the teachers appointed by the college authority on temporary basis for the higher secondary unit used to enjoy the scale of pay approved by a higher education council. It goes a long way to suggest that the prior to issuance of GO dated 6th of January 80, the status of the teachers or lecturer was sometimes volatile. It was for the first time the government took note of the chaotic situation, status of the financially plight of teachers of those higher secondary units of the college and allowed the same scale of rupees so and so as was admissible to the whole-time teachers of the government-aided colleges with effect from 1st of December 1980 by issuing memo dated so and so. By the aforesaid GO, it was made clear that the unapproved posts against which such teachers were appointed for the higher secondary units of the college would be abolished as soon as the post would fall vacant due to retirement, resignation, etc. It was therefore a Personal to the incumbent, the scale of pay of rupees so and so was a new scale allowed to the petitioner with effect from 1st of December 80, and it was not a revision of the earlier scale of pay. The petitioner was subsequently allowed the benefit of revision of pay of the college teachers as per the UGC norms from the time to time and the benefit of career advancement scheme. The argument that the petitioner had to deposit that the employer's share of contribution from the period for 15th of July 76 to 81 as the time of switching over GPF to CPF scheme doesn't appear to be very much convincing because it had nothing to do with the reckoning of his service period since 76. Rather, it is suggestive of fact that when the petitioner got a safety and security of service by virtue of geodated so and so, the petitioner opted to the switch over GPF scheme, and as a necessary condition of such switching over, he had to deposit the employer's shares of contribution. Moreover, from the record, it appears that the petitioner made representation to the Higher Education Department on 5th of November 2014, claiming pension benefit for the period from 76 to 2009, and the department in its memo dated so and so regretted its inability to provide him pensionary benefit for the period from so and so as the said benefit was applicable with effect from 1980. So their case is altogether, since you got the pay fixation from 80, you are entitled to get benefit from that day. That is their case, my lord. If your lordships allow me to show.
Is there any other lecturer who has received the benefit from 76 on?
But that I can't say. That I can't say. My client level that allegation or claim that, but I have no document to show before lordship. I will show certain documents to your lordship. Can you have a look, page 17? Page 17, that's my appointment letter on 26th of May 1976.
Because the recordings over here that the status of the teachers were volatile, they were in a financially pitiable condition. That means you are not the only one who was subject matter of this.
Kindly hear me for me moments, my lord. I think that would be better. That's page 17, that's my letter of appointment on 26th of May 1976. Lordship got it?
1 minute.
Pursuant to this, my lord, the petitioner joined his duty, that is page 19. Page 18 and 19 is, my lord, pay fixation. Kindly have a look to this. This is dated 22nd of May 1981, if I'm not wrong. Subject: fixation of pay of lecturer of the college in the new improved scale. New improved scale in terms of the geodated 6th of January 81. Now, that scale that was granted in my favor, and my lord, your lordship will find out that there is nothing said from with effect from which date.
Fixation of pay, date has not been fixed.
It
will be definitely from the geo.
Now, kindly come to that geo.
It will be prospective. What is the?
Now, kindly come to the geo, my lord. The geo is also here. I have annexed that. That is at page 43. 6th of January 1981. Well, may I read it for you, my lord? The undersigned is directed to say that the higher secondary units attached to non-government colleges at the initial stage functions as separate unit. Later, these units become integral part of the respective colleges in view of the government orders, legislations. It has been reported that some colleges appointed whole-time teachers exclusively for their higher secondary units, and that a good number of such teachers could not be absorbed against regular vacancies in the post of lecturer in view of the fact that they didn't satisfy the minimum qualification prescribed from the recruitment to the post of lecturer in the non-government college, or for non-availability of regular vacancies, or for both the reasons. Such teachers are continuing on mere salary, as a result of which they are experiencing great financial hardship. The question of extending the benefit of grade scale of pay to the aforesaid category of teachers and to other lecturers who could not be absorbed in the post of lecturer for the same reasons has been under consideration of the government for some time past. After careful consideration, the governor is pleased to direct that whole-time teachers of non-government colleges, sponsored so and so, who were in position on 31st of October 79 and who could not be absorbed against regular vacancy in the post of lecturers may be allowed to continue in the scale of pay of so and so. Unapproved post, if any, should be abolished as soon such posts fall in vacant due to retirement or resignation, etc. Further filling up of vacancy in any of the approved sanctioned posts should also taken into account the workload borne by the category of teachers who should be deducted from the total workload. Fixation of P of teachers in the scale of census should be made with effect from 1st of December 1980. This order issued with the consent of so and so. Nobody denies my continuation. Nobody denies my service. Admittedly, I had been there since 76 till 80. Now, 80 is the point when they decided to fix my salary and subsequent revisions were there. Now, this 4 years service, which is otherwise admitted in the institution, can that be curtailed from the length of my service, at least for the purpose of, my lord, counting and disbursing my pensionary benefit? That is the, because I am not asking for salary, I can't. But if your lordships allow me to rely 3 judgments. Nitish Mahato, Nitish Matra, I'm sorry, my lord, is Pastudev. Reported in 2014, volume 4, CHN. Or if your lordship turns to page 4, paragraph 6. We have, by a separate judgment delivered today in WPST number so and so, decided the issue which arise in this petition. We have held that under the DCRB rules, the service rendered by an employee on a temporary basis continuously prior to his being confirmed with the permanent status must be taken into account for computing qualifying service for payment of pension for the reasons stated in the judgment dated so and so. Now, that particular, my lord, WPST 532 that has been, my lord, referred. This is unreported, my lord. Kindly come to page 7.
This is WPST 81. This is WPST 532 of 2010.
Yes. Well, the 532 is the Nimai Chandra. Give me.
This is not Nimai.
I'm giving. Judgment that. My lord, may I refer then, my lord, because somehow I have missed that, my lord. It's 2014, volume 2, 2014, volume 3, Calcutta High Court Notes, page 608.
Which one?
Nimai Chandra. That is, my lord, WPST 532 of 2010. But may I read the relevant portion, my lord?
Is it here? Somewhere?
My lord, I think, my lord, somehow I have missed. My lord, somehow. Somehow I have missed. I'm sorry, my lord.
Yes, what do you want to place from here?
But here it says, because we have considered the DCRB rules independently and in our opinion.
Which portion?
But that Nimai is not your lord with your lordship.
In Nimai, it is not here. In Sheikh Ghulam.
Sheikh Ghulam, it's a different. The same thing, almost same thing, my lord. Ghulam, your lordship, kindly come to page 7.
Yes.
Page 7, Mr. Majumdar, learned advocate representing the state respondent, submits that a special leave petition has been filed before the Honorable Supreme Court of India, challenging the aforesaid division bench judgment of this court in the case of Pastudev Singh, which I have, my lord, cited before lordship. The Honorable Supreme Court didn't, however, stay the operation of the aforesaid judgment passed by the division bench of this court in the case of so-and-so. We are therefore inclined to allow the earlier decision of the division bench of this court in the case of Pastudev Singh and hold that the learned tribunal committed an error by not considering the provisions of Rule 36 of the DCRB Rule 1971 in an appropriate manner. Following the earlier decision of the division bench of this court in the case of Pastudev Singh so-and-so, we also hold that the temporary service rendered by the petitioner herein for long 14 years cannot be altogether ignored, and the government should exercise power under Rule 36 as well as Rule so-and-so to condone the aforesaid deficiency of 4 months, 7 days in the qualifying service of the said petitioner for the purpose of granting regular pension. Now, this was, my lord, appeal against before the Supreme Court. The SLP that has been dismissed. So ultimately, my lord, the denial of the authority to take into account my service from 76 to 80, according to me, that's not permissible, at least for granting pension.
Will you be guided by the DCRB rules?
DCRB either 71 or 81. DCRB is there. The language are also, my lord, similar. DCRB 71 for the, my lord, school education, for the, my lord, state authorities, and DCRB 81 for the school teachers. But the principle is the same, my lord. Let my learned friend, my lord, take instruction from the authority and to apprise your lordship what would be, because a man is getting up, the amount is so
Meager.
It's hand to mouth condition.
Would you like to make submission today or would you like to come back?
I will, my lord. Ideally, my lord, want to come back with instructions, my
with compassion.
The reasoned order dated 13th January 2023, rejecting the petitioner's prayer for
Refixation of pension, that would be better, my lord.
refixation of pensionary benefit after taking into consideration his past service in temporary status is impugned in the instant writ petition. Stop. It appears that the authority considered the petitioner's service on and from 1st December 1980 till his date of superannuation and accorded pension. Stop. The petitioner has actually served in the college on and from 15th of July 1976. Stop. The petitioner praised that the period prior to which the period for which he performed duty on and from the first date of his appointment ought to be taken into consideration for grant of pensionary benefit. Stop. The petitioner relies upon various decisions passed by this court in support of the aforesaid stand. To allow the learned advocate representing the state respondents to revert with proper instruction. Release the matter for further consideration. How soon do I keep it?
My lord, should it be, my lord, 7-10 days subject to my lord's
29th of July, fortnight time.
Great, my lord.
Okay.
next
Next.
13
I am for the petitioner. My lord, the retired headmaster is before lordship, who retired on 28th of February 2023. Till date, my lord, there is no disbursement of either gratuity or pension, 7 exit provident fund.
Why?
The issue, my lord, initially the institution was a Madhyamik institution that was, my lord, upgraded. Now the 3% incremental benefit, that was the consideration. My lord, after my retirement, they asked for refund. So I was compelled to refund, my lord, 3,07,546. This is one. Another thing, my lord, since this is not being regularized, they are not sanctioning my pension. Now, if your lordship stands to this court's order dated 4th of April 2024 passed in my writ petition. Initially, our report was short for from the DI, the Pension Sanctioning Authority. He averred in my favor. He says that 3% that was rightly given to this petitioner.
In terms of a government memo of 2010
That was rightly given to me.
and which was revoked in 2014.
I am someone of 2006 where I was entitled to have this benefit and that was given to me. Kindly have a look to page this 4th of April 2024.
Yes.
The petitioner on attaining the age of superannuation has retired from his service as the headmaster of so-and-so school on February 28, 2023. Divergence of opinion between the two authorities, that is the District Inspector of Schools, Murshidabad, the respondent number 6 herein, and the Director of Pension Provident Fund, Government of West Bengal herein, regarding the admissible scale of pay of the petitioner is resulting delay in disbursement of the retired benefit. Therefore, the said divergence needs to be resolved. The issue for the said purpose be placed before the Commission of School Education, Government of West Bengal, that is the respondent number 5 herein, to get its opinion on it. The opinion of the aforesaid respondent number 5 on the said issue be filed before this court. Now, pending disposal of the present writ petition, the authorities are directed to take steps for release of provisional pension. That has not been done. I am not pressing the same at the present. But this clarification needs to come before your lordship. If your lordships have a look to what report was filed dated 1st of September 2023, I believe that is in the that shows that is by DI, my lord. First page, last paragraph of the your lordship got it.
I can see writing by the senior law officer of the DPPG. The report of the DI.
Yes.
Yes, a DI report is here.
The first page, last paragraph.
Hmm.
From the basic interpretation of such provisions of para so and so, it prima facie appeared that since the petitioner was appointed prior to 1st of January 2006 to the post of assistant headmaster, so the increment which he availed to the said post was emerged with that of revised pay of headmaster, in which he joined on 1st of September 2008, and consequent thereupon the pension file of the petitioner was forwarded twice to the DPPG West Bengal, that is on 5th of September 2022 and 27th of February 23, respectively. After maintaining all formalities as required from this purpose, it is needless to mention that all the steps have already been taken with regard to finalization of the pension case of the petitioner prior to the date of retirement so and so. But the DPPG West Bengal did not deviate from its earlier observation, and thereby providing that the interpretation of para so and so on the part of the pension sanctioning authority being so and so was failing in zone of misrepresentation. Now, this is the dispute in between pension sanctioning authority and DPPG, and I am the sufferer. So let a clarification come from the commissioner as was directed by this court on 4th of April 2024. Already 2 years gone, my lord.
Did you get the papers of this
My lord,
case?
here papers I have not received of this case, my lord. My lord, I have just downloaded it from my lord. But my lord, I am told, my lord, there is a report earlier submitted, my lord. But perhaps, my lord, that will not suffice in this matter, my lord.
No, 4th of April, there is a direction
There is
for
a direction
filing a
that has to
report.
be complied with.
Thereafter, the matter has not been taken up, so report cannot be filed. Please come.
My lord, then the Commissioner.
The petitioner retired from service on February 28, 2023. Stop. He has not received his terminal dues till date. Stop. Paragraph. By order dated 4th April 2024, the Commissioner of School Education was directed to give his opinion after consideration of the divergent opinion of the District Inspector of Schools, Secondary Education, Murshidabad, and the DPPG. Stop. Released the matter on 29th July 2026. Stop. The report of the commissioner shall be placed before this court on the adjourned date.
Subsequently, there are development because coordinate bench passed that order 3% entitlement travel to division bench. So those are in my favor. However, let that clarification become. Your Lordship fixed it on
29 July.
29.
weeks.
Great mark.
Copy page.
My lord, I beg to appear on behalf of the petitioner. My lord, kindly excuse me. Yesterday I could not appear.
It's all right.
No, that's why they've given the copy now. See this one.
My lord, only thing is this, my lord. ও কিছু বলবে নাকি এই লোকনাথ কিছু বলবে?
What is your prayer?
No, my lord, kindly before my lord, this is the second time litigation, second round. It's covered by the decisions of this honorable court and the larger bench that I am entitled to the higher scale of pay. Now, my lord, it is well settled that a law, a act or rules, unless it is specified, given a retrospective effect, it cannot be given retrospectively. Earlier occasion I moved and this court passed order. The impugned order is at page, rescind order, page 33, annexure P7. My lord, may I place it? In compliance with the order of the Honorable High Court, Calcutta, dated so and so, passed in the above writ petition by His Lordship, the Honorable J.C. Rajasagar Montar, a matter has been taken up for decision. The school authority has been requested to submit the relevant papers and documents in respect of the application made by the petitioner. Subir Das, assistant teacher of so and so school, regarding his higher scale of pay. All the submission, records, information, and representation of the petitioner is taken into consideration. It is observed that the petitioner Subir Kumar Das has been appointed as an assistant teacher in the group of work education, physical education with qualification BPEd with effect from 2004. My lord, kindly mark it. In the postgraduate scale of pay under graduate teacher category, according to the section 14(2) of the West Bengal School Control Expenditure Act 2005, every teacher of a school shall, if appointed in the post of graduate category teacher, be entitled to draw pay in the scale of pay so and so. The petitioner obtained master degree in 2003 prior to my appointment. As per 7 of GO number so and so 2007, no teacher who has been appointed with graduate degree and graduate scale of pay at the time of entry into the service joining at the school will be allowed higher scale of pay for acquiring any higher qualification before or after introduction of the West Bengal School Service Commission Act 2005. Now, my lord, here question is when I was appointed. I was appointed in 2004. I was completed, my lord, my master degree, my lord, in 2003. Now, my lord, there was no distinction, no honor scale or master degree vacancies in the notification. Now, my lord, this question came up, for your lordship knows, my lord, Utpal Kanti Karam. It has been said that too, my lord, my lord, the reliance of 14(2), 2005, when I appointed, my lord, 2004, it cannot have the retrospective. It is the settled law. Now, my lord, I am placing, my lord, one division bench judgment. I had an opportunity to appear before your lordship, before the honorable division bench. It to Dinna Joseph. I did it, Loknath. My lord, I am placing, my lord, paragraph 2, page 2, paragraph 3. He submits, my lord, it is the appeal of the state. He submits that the impugned order was passed without taking into consideration the provisions of the West Bengal School Control Expenditure Act 2005, which debars a teacher from claiming additional increment of higher scale of pay for acquiring any higher qualification. Well, therefore, my lord, kindly my answer to that, page 3. Mr. So-and-so learned advocate appearing for the writ petitioner denies and disputes such contention and submits that the issue as regards grant of postgraduate scale of pay to physical education teacher is no longer res integra, and the said issue has been decided in the cases of so-and-so, as well as the case of Utpal Kanti Karan versus State of West Bengal and others reported in so-and-so. Now, my lord, then, my lord, paragraph 12, page 4. My lord, got it. The issue as regards entitlement of postgraduate scale of pay to the teacher in physical education and work education group has been considered in the judgment delivered in the case of Boishali Banerjee Supra. Dealing with the judgment cited, the learned single judge rightly observed that in physical education there is no such distinction between pass category and honors category, and that as such physical education teacher with master degree in physical education would be entitled to the postgraduate scale of pay, notwithstanding the fact that the postgraduate degree in physical education was not necessary for appointment as assistant teacher in physical education. The 2005 Act also cannot have any retrospective operation, nor will stand as a bar in extending benefit of higher scale of pay. Now then, my lord, the appeal filed by the state, my lord, has been dismissed. There are other several decisions on similar point that to the single bench. Now, my lord, I am placing another decision. Justice, starting from Justice Justice Saraf, এটা নয় আরে আমি যেটা করলাম ওইটা কোথায়? রায় চট্টোপাধ্যায়ের ঘরে একটা করলাম, জাস্টিস রায় চট্টোপাধ্যায়. Now, my lord, this is, kindly have a look, my lord, this is a judgment reported in 2009, volume 1, CHN, page 561. My lord, kindly have a look to this. This is in respect of, my lord, giving effect of retrospective operation of the 2005 Act. The teacher attained higher qualification, authority refused to approve higher scale of pay, authority relying on provisions of 14(2) of 2005 expenditure at the head notes. Higher qualification attained before enforcement of 2005 Expenditure Act 2005. Act not having any retrospective effect, authority not justified in refusing petitioner's claim for higher scale of pay, relied on 2008 1 CLJ Calcutta 810. And my lord, another এটা দেখবে দাঁড়াও. Now, my lord, another decision, এটা ডালিয়ার আরেকটা কোথায়? Another decision, my lord, kindly have a look, it is unreported. ওটা ইয়ে এই যে হ্যাঁ. Para 2, the case of the petitioner is that he had obtained a master degree in physical education subject in the year 2003. Thereafter, in the year 2004, that is on 1st April 2004, she joined the service as an assistant teacher in pass category. According to her, as per Rule 12, Clause 3 of the ROPA 1998, she is entitled to the said benefit. Clause 12, my lord, relied upon. Then, my lord, internal page 2, paragraph 4, series of decision, my lord, has been relied upon, and ultimately court held that I am entitled, this petitioner was entitled, my lord, to the higher scale of pay, and the writ petition was disposed of. Now, my lord, I am just referring, my lord, dates. 2004, I was recommended by the School Service Commission. I joined on 8th of April 2004, and I was approved. I made a representation for high scale of pay. Nothing was done. I moved the first writ petition. Court directed you make a press representation, and my lord, on the basis of that, my lord, this impugned order was passed. My respectful submission is this, my lord, this order, reason order, dated 31st of January 2023, cannot stand. Relying upon the series of decisions, including, my lord, Utpal Kanti Karan.
Are you getting anything now?
My lord?
Are you getting any pay, pension or anything?
No, I am still in
service.
Still in service.
Still in service. Yes. Would you like to come ready?
I believe, my lord, I should.
Go through the judgments.
I will have to, my lord.
There is a special bench judgment in the matter of Utpal Kanti Karan, which is also
relied
upon with this issue.
My lord, the 2024 judgment.
Yes.
Citation of
Utpal Kanti Karan, 2024.
270 probably 73 pages.
Huh? And see whether this 2005 Act can be given any retrospective effect or not.
My lord. उसे आगे page है ना graduates.
How long will you take?
Huh.
1 week will be all right. This
My lord,
matter.
I'll come back on 29, my lord.
29?
Yes, my lord. My lord has been kind enough.
Acha. The recent order dated 31st of January 23, passed by the District Inspector of Schools, Secondary Education, Birbhum, disallowing the petitioner's prayer for grant of higher scale of pay is impugned in the instant writ petition. Stop. Specific submission of the petitioner is that the West Bengal Schools, bracket open, Control of Expenditure, bracket close, Act 2005 cannot be made applicable in case of the petitioner, as he obtained his higher qualification prior to the coming into effect of the subject act and prior to getting his appointment. Stop. Reliance has been placed on several decisions passed by this court in support of the aforesaid submission. Prayer has been made to set aside the impugned order and direct the authority to grant higher scale of pay. Stop. Learned Counsel representing the state respondents intends to revert with necessary instruction. Stop on such prayer released on 29th of July.
Utpal Kanti Karan is 2004 SCC online, Calcutta 1274.
Take note of it, please.
And my lord, 2008 2 WBLR Boishali Banerjee.
অনেক জাজমেন্ট ছিল উৎপলকান্তিকরণ মোটামুটি
'24 SCC online. Deeply obliged, my lord.
This is of 2023. Today I have served the copy of the writ application, my lord. And this is
What is your prayer?
prayer, my lord, to the school in question, my lord, recognized in 2021, and the my lord, formal recognition in 2020. Since then, the my lord, school is running, and in school, all the teachers appointed from the School Service Commission. The building in question from the government fund. Now, my lord, there is a dispute there is another organized school there. It was started and they filed it. Then thereafter, my lord, the Honorable Division Bench asked to inquire, and only dispute is that the land which was given, at the time of inquiry, the landlord was present and said, I will give it. And he was given. Well, no, the affidavit, the gift was made after the inquiry session. But it is continued from 2001, my lord, till it is recognized.
Where is the impugned order?
Impugned order, my lord, that is now the West Bengal Board of Secondary Education. They have sent that it will continue its recognition. Only state said you make a fresh application.
Is there any impugned order?
Yes, my lord.
Where is that?
That is, my lord, at page 89, 93. 89, 93.
Impugned order? This is 2009 order.
Yes, my lord, that is its conduit.
And
That
this
is,
you
that
are
is thereafter that
challenged?
another writ application, and thereafter, my lord, there is a judgment. And there is a judgment, my lord, that is page 21 in 2023.
Well, if two schools were running, my lord, the petitioner school was granted recognition.
This is also in 2007. The writ petition is of 2023.
Yes, Well, that is disposed of in 2023. And my lord, I was
My lord, may I, your lordship, this particular petitioner school was recognized provisionally by board. Thereafter, lordship, another school claiming that we are the original school, this is not the original school. Why have you given their recognition, not mine? So, my lord, petition was filed. My lord, Justice Barrett was then, my lord, he was pleased to set aside the recognition of the petitioner school and asked, directed to recognize the other school. So, my lord, appeal was preferred. So, my lord, the order of the appeal division bench at page 48, well, where the division bench directed the state authority to hold fresh inspection in respect of both the schools. So, my lord, thereafter, my lord, the order was passed in 2006 by the division bench. My lord, inspection was held, and my lord, in 2007, my lord, the Principal Secretary Education Department did not recommend for extension of recognition of the petitioner school because, your lordship, that was a provisional recognition, and thereafter, my lord, extension was not given. In the meantime, the extension lapsed. So, my lord, that is at page 94. This is the order.
Now, after 2007, what happened? The school is functioning.
Still it is functioning and with
Without-
the approval of
without
this court.
There is no approval, your lordship. Because, my lord, we cannot approve or give an extension of recognition to a school without permission from the Commissioner of School Education. This is the rule.
So, what is the position of the students now? Are there any student in the school?
Yes, unless that is continue as per the judgment of the this honorable court. Justice kindly come to page 27, judgment of the
How
honorable
many
justice.
students you have in your school? How many students are there?
Now many students are there. Well,
How many students? Your
present
school doesn't have
about
any recognition.
no, still recognition, my lord. Still continue. Still getting salary. They are getting salary from the state.
The school
Service commission.
Lordship, kindly come. The district inspector of school have asked this particular school to apply afresh for recognitions as a new setup school.
But the board said this they will not need not. They will continue with the same recognition.
How can board say?
He's appearing. She's appearing for the
The
state.
teachers are paid from the state exchequer.
Yes, my lord. We appointed by the school service commission, and that is school closed. That is school closed. My lord. That is closed before 10 years.
Nothing of any annexion to that effect has been added.
Well, I have stated in oath. There is no school. That school is running as a marriage house now. Nothing there, my lord.
Marriage house.
Marriage house. That is closed marriage house.
That is the other school who challenged this school's
Now there is a
recognition.
direction of losses can see. Take report from losses can see.
Extension
Last order on 22nd.
recognition of this school has been negated by the Commissioner of School Education. That is at page 30.
And the other school was directed to be recognized. Now,
No.
that is also
That is it.
so. So none of the schools had recognition.
No, I am running as per direction of the honorable court.
Board, there is no.
Why don't you go and inspect and see what actually the position is?
I think that is a lordship. DI may be given a direction to submit a report. সেটাই ভালো হবে। To give-
That is the direction. That is the direction on. That is the direction on 22nd April 2024.
There is already a direction.
Yes, my lord.
কোথায়? কোন পেজে?
No. Courted order. Justice Vishwajit Basuru. 22nd April 2024.
So there is no direction.
Yes, my lord. 22nd.
Take instruction. It's only to take instruction.
Yes, my lord. Take instruction by the state authority.
Not inspection. Take instruction. and,
Instruction. That is.
inspection, two different things.
And to submit report.
Yes, yes.
My lord, let them submit report.
Yes, please come.
You are appealing for board. What is the board view? Board said that it will continue. Board said it will
Is
continue.
it in writing? Which
Yes, my lord,
page?
yes, my lord.
Which page? The petitioners pray for recognition of the school named number 1, Ranishire Hindu Junior High School. Stop.
A list of students also given in here, my lord. That is in
Page.
2023. Page 23, page 101.
Page 101.
It is in 2023. Now maybe it's more or
159 students.
Hmm.
Acha. According to the petitioner, the school is functioning.
4th class school, 4th class. It is a Hindi medium school, Hindi medium.
Words.
West Bengal rules এর under
Stop. Paragraph.
8 act এসছে তারপরে West Bengal rules এসছে.
From the documents annexed to the writ petition, it appears that the recognition of this school was disallowed by the Commissioner of School Education in the year 2007. Stop. Learned counsel for the petitioner submits that the board orally permitted the school to continue functioning. And till date, the school is functional. Stop. The teachers of this school are being engaged by the School Service Commission. Stop. Payment of the salary of the teachers are being made from the state exchequer.
And that is also as per direction of this Honorable Court. That is that page 27, 28. Hmm. And no. Justice Sogato Bhattacharjee. Considering the entire gamut of the issue, page 27. Or directly losses can come to page 28. Page 28. The appointment in the petitioner's school on recommendation of the School Service Commission were directed not to withdrawn, and by subsequent order of 2011, the another coordinate bench extended the interim order till disposal of the application. However, it is made clear that the writ petition is filed.
Learned advocate representing the West Bengal Board of Secondary Education.
And there's a order of status quo, my lord.
Denies the submission of the petitioner that the board permitted the school to continue functioning without recognition. Stop. Paragraph.
And there is an order about status quo at page 28.
Learned advocate for the petitioner insists that insists that the subject school is the only school in the locality, and there are several students in the said school. Stop. Paragraph. To ascertain proper facts as to whether there is any scope for grant of recognition to the subject school, the District Inspector of Schools, Secondary Education, Paschim Bardhaman.
Yes, ma'am.
Is directed to.
It is Raniganj, from Raniganj.
Is directed to conduct a spot inspection to ascertain proper facts. Stop. The proper facts. Stop. A report of inspection shall be placed before this court on the adjourned date. Stop. The report shall.
By way of affidavit,
indicate the number of students in the school, the number of approved teachers in the said school. Stop. Stop na comma diye. Whether the does the students go up for the boards from your school?
No, up to class 8. Due to litigation, it cannot be upgraded.
Junior high, right?
It's
Junior high.
Junior high, yes.
It cannot be upgraded due to litigation.
As to whether the subject school has the proper infrastructural facilities required for recognition of the same.
এগুলো 15 বছর আগে এরকম ছবি দেখে মনে হচ্ছে
Release the matter for further consideration on 10th August 2026.
10th August, my lord. Let them file the report by way of an affidavit.
Let the report come to the court and then I'll see what is to be done. Yes, 16.
16, my lord. And I think this is HRA matter, my lord, covered by your lordship's order. The only difference is that, my lord, the petitioner is praying for area HRA. Currently, she is receiving, but from 2018 to 2023, my lord, her area HRA was not paid. But she made a representation.
Yes, did you make a representation
I made-
disclosing the period for which HRA was not given?
Yes,
Where is it?
that is at page.
husband private sector.
Private sector.
When 29 এ একটা করেছে
Page 29, if you lordship kindly have a look, my lord. Pursuant to that representation, my lord, her HRA was released from the month of August 2023. But the area, my lord, from January 2018 to July 2000.
Where is it mentioned? Stopped from January 2018
Yes,
till July 23 is due.
yes. My lord,
Where is the representation?
further representation she has not made, my lord. From January 2018 to August 2023.
No, from August you are getting, you say. That means till July. Or from September are you getting?
September. I have
So
stated
till
in my
August.
petition from September I am receiving
From January 18.
to August 2023.
Ajay, please come. The house rent allowance of the petitioner was abruptly stopped by the respondent authority on the ground that her spouse was receiving house rent allowance from his employer. Stop. The petition, acha, the period for which house rent allowance has not been paid to the petitioner is from January 18 till August 2023. Stop. In July 2023, the petitioner submitted a representation before the authority through proper channel. Stop. After submission of the representation, comma, the authority resumed payment of HRA on and from September 23. Stop. Paragraph. The petitioner in the instant writ petition prays for releasing her arrear house rent allowance for the period January 18 till August 23. Stop. Paragraph. Whether the teacher engaged in a government aided school would be entitled to receive HRA if his/her spouse receives HRA from any private organization has been conclusively decided by the court in a batch of writ petitions by the court on 16th March 2021 in a batch of writ petitions, first of which is WPA 1389 of 2018. Moushumi Biswas and another versus State of West Bengal and others. Paragraph number 4, please copy. Bracketed portion. Paragraph number 5, copy. 6, copy. Then add.
Oh, yes.
It appears that after receiving the representation from the petitioner in July 2023, the authority realized the mistake on their part and accordingly resumed payment of HRA in favor of the petitioner. Step. As legally, the petitioner would be entitled to receive her HRA. Accordingly, the District Inspector of Schools, within bracket Secondary Education, South 24 Parganas, is directed to take steps for releasing the arrear HRA, which the petitioner is entitled to in accordance with law, at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. As the petitioner was entitled to receive HRA in due time, accordingly, the arrear HRA shall be paid with simple interest at the rate of 5% per annum from the date it fell due till the date of actual payment. The writ petition stands disposed of.
While the DI will take decision, my lord, he will consider the judgment. Moushumi wishes judgment.
That's direction.
There is no question for any hearing because they have released your rest. If they would have not released, then a hearing would have been called for.
No, considering the judgment of Moushumi
Your direction. Well, this is covered, my lord, entirely and by Moushumi. These issues are covered.
Rahul?
For the petitioner, my senior is appearing virtually.
My lord, on behalf of the commission, I've been instructed to make one submission that if the matters could be adjourned for 2 weeks, the entire, yes, this entire second SLST,
All right.
since we are presently not taking any steps with regard to the second SLST recruitment.
Are you appearing for the commission now?
Yes, no, I'm appearing throughout. I've not
No,
been.
the earlier matters.
No,
were-
the second SLST at that point of time, there was
You
a
were not appearing.
there was a separate set of
counsels.
advocates. That is also one issue which they have not yet finally decided what will happen.
All right.
But yesterday, the secretary has requested me to pray for 2 weeks adjournment because we are not presently actually proceeding with this recruitment due to the circumstances in the commission. We do not have
All right.
the entire bunch we are praying for.
What will happen to the Supreme Court timeline?
Possibly there will be a prayer for extension because
What is going to happen to these candidates? Very
Sir,
sad.
lots of persons are suffering.
Very sad for these people who are without a job for years together. 2016 appointment lost. Very sad. And then I'm not passing any order in this entire bunch.
Yes.
Because recording order in each and every
No, it
case
is not
doesn't
necessary.
make
Let
any-
it simply
doesn't
just-
make any sense.
we adjourn,
Can
let
we
it.
fix a date because many matters are to be
2
discussed.
weeks, he says 2 weeks, so we'll go to the
After 2 weeks, can we fix a
month.
date and time?
Next month we'll go. 3rd of August in the combined list, these matters will remain. In the meantime,
Yes,
you set your house in order
My lord.
and see what can be done.
Deeply obliged.
Because I do not know.
Yes.
A lot of issues to be dealt with.
My lord.
Lot of issues to be done.
reservation.
That's a
Yes, that's the biggest right now.
10-mark
10 mark.
issue.
After expired.
Old versus new.
And hereafter, after
But
expiry.
tainted candidates appear. That is also one
So
issue in
those
2025.
we can tackle when they're taken up, but before that we need to set the house in order, as the court has
Yes,
said.
that is the first thing which you should do.
We need somebody to take the decisions and give us the instructions. That is the thing.
After yesterday's decision, the whole selection process now is another jump because of that.
Which yesterday's decision?
Because of that, the OBC issue. Because
That,
11, 12, that recommendation completed, but they're not joined. But that due to that exam period, this whole selection process was done. So again, the recast occurred.
I do not know. I really pity those candidates. Very well. Then the entire bunch of SLST matters goes.
Next monthly list.
Next monthly list.
If you're obliged.
ডাকা হবে তাহলে এখন
পুরো জিরো সিং।
Convenience, business permits, well, a transfer matter can be given a day so that it is one line order, it can be disposed of as a whole, all the transfer matters.
one line order.
Well, common order, my lord, usual common order, my lord. No, transfer order, consideration or liberty.
No, but then the court had permitted this liberty, isn't it?
My lord, court has?
Yeah, for the similar order.
Yes,
they are asking
therefore.
for. In each and every matter, your lordship has to give the liberty.
Yes. In the other benches, you didn't get. And so whenever this bench is there, I know you all will jump. And I have permitted it. Right?
Well, only
I
consideration.
thought SLST matters, Supreme Court direction is there. That is the reason I
Right.
posted it today. But since with the change of circumstances, I'll put up the transfer, the pension, and
Yes,
these matters will come up in the list.
Yes.
Transfer to বেশি তোমার এ হবে না।